আর নিলেও স্যার Miller, may I am praying. Permitted to.
Why you're mentioning? We take mentioning on Thursdays and Mondays.
Lordship,
Coming.
Lordship,
We have indicated in the list.
Lordship asked me to mention immediately for enlistment. The matter was item number 5. Hearing was concluded. Lordship just
We give this.
My lord, leave, my lord, without certified copy. I applied.
When was the order passed?
15th of May, my lord.
You applied when?
My lord, on 9th, my lord. Now, in the meantime, my lord, I will file. My lord, this is a sleep, my lord. I have on last occasion when I mentioned that the sleep
Any
was not there.
urgency is there?
Urgency is there, my lord. A fire was not registered in respect of my first complaint, my lord. This is the, my lord. Let me file the appeal, my lord.
Leave grant.
My lord,
Well,
we have
the-
to file without certified copy. My lord, the order is of 3rd April, but my lord, yesterday's item number 8, my lord, which has been adjourned to 23rd of June, my lord, on the mentioning of Mr. Banerjee and Mr. Learned Advocate General was there, my lord. My lord, same order is there, my lord. My lord, 14 matters were together, 14 orders have been passed, so we are having to prefer the appeal, but the order, whatever order is passed in the yesterday's item number 8 will govern everything. Order is same, all the words are same.
So this is another appeal filed by state.
Two more appeals filed by the state. We are having to file it because 14 orders have been passed.
In 14 matters, state will prefer appeal.
If it's
Common judgment.
no,
Then
same judgment, same order in different matters. It's not clubbed together. Same cyclostyle order has been passed.
so when did you apply for certified copy?
19th of May. Almost a month,
Leave granted.
grateful.
similar prayer without
And to
certified.
file offline.
Nowadays, we have to do away with the process of certified copy. Nobody is applying for certified copy.
Yeah,
All matters are urgent.
Well,
And
this
when it appears, advocate is not there.
Disconnection has been made of the petitioner without notice, without outstanding due.
When?
Thereafter, my lord, the direction
When was the disconnection made?
that is, my lord,
Give me that
4th of May 2005.
When did you apply for certified copy?
We applied and the just 22nd May, the order passed. 22nd May, order
4th May, you said?
order passed.
For
Ordered by the
22nd.
landed. Yes,
Certified copy application.
yes. Two matters.
My lord, may I be permitted to mention to suspension of sentence from the list of my lord Justice Bharodaj?
Remind us on Thursday. We take up mentioning on Thursday. You
Yes.
remind us.
My lord, time to mention a matter.
Mention
My lord,
on
it was,
Thursday.
it was
Today's
mentioned yesterday regarding the Ponzi scheme matters. The Rose Valley matter, your lordship, my writ petition has to be tagged along with that matter.
Why? Why?
It is a similar matter. It has to be heard together with the Rose Valley matter. Similar matter, your lordship. It has to be tagged along with the yesterday mentioned matter.
That was for releasing the matter.
No, your lordship.
That matter was mentioned so that it can be released. ওটা কি তোমায় নম্বর দেয়নি? the list. So mention when his lordship returns. Yes, call the list.
Lordship, I'm for the respondent in item number 5 today's list. I'm led by Mr. Jishnu
Wait,
Shah.
sir. Wait, madam. You don't want to be in court. Wait, let it be called on. Yes.
Okay, my lord, this is my affidavit of service, my lord. Initially, I have made a complaint, my lord, that my daughter was, my lord, kidnapped, and thereafter, my lord, this habeas corpus was filed, my lord. But subsequently, so for my instruction, my lord, the girl was recovered. Now he is in home, my lord, in a home. Therefore, my lord, this matter now.
Appearing for the state lordship report, girl has been recovered, victim girl, and the FIR accused is in police custody.
FIR has been lost. I have
I'm led by
amended
Mr. Mukherjee lordship, so giving his name.
The learned advocate appearing for the petition. In view thereof, no inter. In view thereof, no interference called for in the corporation petition, and the same being at law.
As listed.
For the respondent number 1, praying for not today.
I am praying for the statement.
Your Lordship, can you see my lord's order, last past an order in this matter?
Respondent number 1.
One karo. Last order.
Yes.
Lordship, I am appearing on behalf of the respondent number 1. I'm praying for not today. As my learned senior is appearing in this matter and he is unable to attend the court today due to some
So
personal.
how many times you will pray for adjournment?
Now, what? This for the
This is
respondent.
just you are buying time to stall the matter. Who is your senior?
Mr. Vinayak Chaube, due to
Pardon?
some Vinayak Chaube, due to some
Where is he?
due to some personal difficulty in his family, is unable to attend the court today, Lordship. Kindly praying for not today.
But respondent number 1 possibly was the petitioner, at whose instance the order was passed for demolition. Therefore, my lord, he cannot have now rightly, my lord, to say anything, because the appeal has been preferred by the persons, my lord, who is going to be affected because of the order of demolition by the court. Therefore, my lord, the Ikramuddin, my lord, as on this day, cannot ask for any time, because at his instance the order of demolition has been passed by the honorable single bench.
We know that Mr. Ghosh, personal ground is saying he's coming.
But I do not say anything, but personal. But I say, my lord,
His substitution has been allowed.
Today it has been listed, my lord.
Listed.
Yes. On the last occasion, it was not there on the
By
court.
the-
But now it
No, substitution. The appellant number who has expired?
one
Name.
name.
Al-Fazur Rahman.
My lord, Afjalur Rahman. That is the
You
respondent.
are the appellant.
Right.
You preferred leave to appeal. You preferred leave to appeal
Yes.
against which order?
No, leave to appeal কেন? তোমার তো এটি ছিলে।
No, I was there. I have not filed any application for leave, my lord. I was there as a respondent, my lord.
Well, he was there in the contempt petition, the order passed by the honorable single bench. In the contempt petition, that against that order he came to the division bench. In the writ proceeding he was there, and the order was passed by the honorable single bench for demolition.
He
Then
was-
contempt proceeding was initiated.
He was the respondent in the writ.
Yes.
Where is your substitution application?
My substitution number can 3, my lord. And my lord, it is there, my lord, in the list today.
Uh-huh.
Your Lordship, on the last occasion, I asked my learned friend to submit their undertaking, my lord, on which date, my lord, they will vacate the premises.
Yes, what is your instruction, Mr. Prasad?
My lord, I have taken instruction in the matter, my lord. There are 2 floors have already been, my lord, demolished by the municipal corporation, my lord. Now, so far, the 2 other, my lord, floors are there. There are 6 tenants are occupying that flats, my lord. They are saying, my lord, somebody has met with an accident and then one of the children, my lord, is in Chittaranjan hospital. I have seen that photograph.
So they are not going
No,
to leave.
no, they are saying, my lord, some time should be given, my lord.
Tell us what time.
My lord, at least 6 weeks, 6 months, my lord.
6 months
My
time.
lord, they have to, my lord, alternative accommodation, my lord. It's a question of livelihood, lordship, kindly. My lord,
So this order was passed much
my lord,
earlier,
I
Mr.
know, my lord,
Prasad.
but your lordship, kindly, my lord, appreciate the predicament of my client, my lord. They are persuading all the tenants, my lord, to vacate because it's a illegal, my lord. We have already said, my lord, that there is no question.
No, no,
Sometimes, my lord,
you
sometimes.
are the landlord. You are the
Yes,
landlord.
yes.
Who are the tenants?
Tenants are there, my lord, in the.
How many? Whose son is ill? Which tenant's son is ill?
My lord, one of the tenants, क्या नाम है? My lord, just my lord. He has shown, my lord. Gulam Mustaq, my lord. One of the tenants' name is my lord Gulam Mustaq, whose son is my lord is still in hospital, my lord. Met with an accident.
Mr. Prasad, this
My lord,
order of demolition.
My lord, I want, my lord, yet it should be, my lord. But lordship, my lord, your lordship knows, my lord.
You have already vacated two
floors
has
have been vacated,
demolished.
my lord, yes.
So they are aware that there is an
Yes,
impending
Yes,
demolition.
but I am beseeching your lordship, my lord.
How much can we extend the
Yeah,
time?
my lord, this would be the last.
Moreover, you are the landlord. You are coming and saying you are giving an undertaking on their behalf. The tenants are not before us.
No.
The tenants are not before us.
Yes.
So what is the value of your
my lord, in that fashion, I cannot give, my lord, undertaking.
Then?
Because, my lord, tomorrow he may not vacate.
Are you residing
I can
there?
persuade, my lord.
Are you residing there? Are you residing
Yes,
there?
I was residing there, my lord, in the now I am in the ground floor, my lord. Now
You are in the ground floor.
my lord.
That is not the subject.
That is not the subject matter and all that, no, for that demolition. Only, my lord,
Who were there in the first 2 floors which were demolished?
First floor.
The 2 floors have been demolished.
Fifth कौन था? वो tenants था. Acha, my lord, they were all together, my lord, 12 tenants, but my lord, in fourth and fifth and sixth floor, my lord, they were, my lord, all owners were there. So they have, my lord, there was no problem with that, my lord. But only the problem is, my lord, with regard to 3 and 4. 4, my lord, that's why, my lord, we are persuading them to vacate this, my lord, because, my lord, now the order has come, my lord, from the court, my lord. So, my lord, they are asking for some time. They have said, my lord.
So how the court will believe your version? Tomorrow another tenant will come and say that no, I didn't give any undertaking. You produce a written undertaking of the persons who are occupying the remaining portion.
My lord.
You produce a written undertaking before us that when you are going to vacate the premises.
That would be, my lord, yes, formally. I will do so, my lord. Kindly give me, my lord,
Yes, madam, what you are doing?
submitted by the state.
Well, we fixed a program, my lord, for demolition requiring the police to get the premises vacated. The police says that since the Eid my lord, festival is there, that immediately they are unable to take actions, my lord, on that. I have got a report from my authorities. কততলা বানিয়েছে? পাঁচতলা, পাঁচটা additional floor বানিয়েছে, চারটে additional floor
April 2024.
বানিয়ে গেছে, চারটে additional floor বানিয়ে দিয়েছি। হ্যাঁ, ভিত্তি কিছু করিস নি।
So, madam, this is not a satisfactory report. You are expressing your helplessness in throwing away the persons. This is not a report which is expected from. Who is this Korea police station officer in charge? What he will do? Then, if you are incompetent, we will ask the military to take over. We will ask CRPF to take over. You cannot just shun away your responsibilities on the basis of a mere note given by a officer in charge. Your higher officials are involved. They came before this court. They said that we are taking steps. Did you have a talk with the commissioner about this matter?
No.
You better do that thing, otherwise we will be constrained to call them in court. Now, how long we will wait? Matter has Mr. Ghosh first appeared prior to the vacation. His report was insufficient. We asked him to file a fresh report. He has done so. He is expressing his helplessness that unless the police assistance is given, how can I demolish?
But the Karapi says that he has given.
You made loudspeaker announcement and went back home. Police is for that. Then please don't, what should I say, push us to take some action which will be derogatory to your faith. What is this? Before the Chief Justice, you came and said that, yes, sir, we are taking all steps. An order was of 4th of April 2025, already 1 year gone.
Yes, madam.
Contempt order was passed on 4th of April 2024,
30th of April.
where you are asked to demolish. Come to the order of 4th of April.
30th of March.
Fourth
April.
April,
4th April.
Justice
4th
Sinha,
April 2024.
Justice Sinha order.
Gotcha. Demolition.
Your deputy commissioner of police was asked to arrange for vacating the unauthorized portion. Have you gone through it, madam?
Yes, madam. But at that
I
time,
think
my
you
lord,
have not perused the earlier order.
time, my lord, I was not there in the matter, my lord. In the contempt application, I was not appearing, my lord. I was not in the panel also.
Then who would be assisting us? You are appearing for the
Now
police.
I am appearing, my lord.
You were previously appearing in the writ matter.
In the writ I was appearing.
Yes.
Then my name was struck off, my lord.
Yes, because there was no appearance, we were constrained to direct them to serve notice upon you.
It was not in the pen.
Just zero. Just zero. The application একটা ফাইল করেছিল অ্যাপ্লিকেশনটা ডিসমিস হয়েছিল Mr. Prasad, you have also not gone through the records. The persons on whose behalf you are saying that give us some time, those persons themselves filed an application before this court. That application was rejected on 10th of March 2025. This is the assistance you are giving. Your learned advocate on record is not informing you of the facts.
My lord, whatever is
Ask your junior, did he see this letter? Why you are misleading us? 10th of March 25 ordered, your application of the tenant was dismissed.
10th of March. ঠিক আছে? March পাঠাইনি।
এখানে বললো কে বললো ডেপুটি কমিশনার কে আগে ডেপুটি কমিশনার অ্যারেঞ্জ করে
আগের অর্ডারটা বললো ডিসমিস করে স্যার 10th of March এর অর্ডারটা আছে
অ্যাপ্লিকেশনটা কোথায় জানো
এই অ্যাপ্লিকেশনটা
কেন
এই যে পেজ
কি বলেছে
ছেলেরা মেয়েকে হাসপাতালে আছে
টেনেন্টরা একটা অ্যাপ্লিকেশন টেনেন্ট ক্লেমিং টু বি and we will, if the police is incompetent, we will ask the CRPF officials to remove you. You intimate this to the tenants. If they cannot give, their application has been dismissed, we cannot modify the earlier division bench order.
My lord, your lordship cannot, my lord, but one thing, my lord, humble
Very
submission.
good. Your
Humble
son is
submission, my
sick,
lord.
we appreciate. Your son is sick. But for that, entire bunch of tenants cannot seek protection.
My lord, the entire building, my lord, that illegal building, my lord, a portion, my lord, will be vacated, my lord. Only your lordship can grant some time,
We are
Lord, so
giving
that
you
we can
time.
persuade, my lord, and all. Today,
Grant of time to you would not suffice because you are the landlord. you are saying that some tenants are occupying those portions.
No, your lordship's my lord, earlier what has fallen from your lordship, my lord, that we should take, my lord, at least, my lord, undertaking that when they are going to vacate, my
No,
lord,
no, that
within a
we-
very
that is
reasonable time, my
because
lord,
you did
that I
not-
will do.
That is because Mr. Prasad, you
I
did
have
not
seen, my
read
lord,
this-
I have seen, but lordship, kindly, my lord, I'm not going into all those questions, my lord, but only I am beseeching your lordship, my lord, kindly give us, my lord, at least 2 weeks time, lord, so that I can take, my lord, written.
Sorry, Mr.
And my lord,
Prasad.
my lord, my respect to my lordship, kindly, my lord.
Sorry, Mr.
My respect to lordship, kindly, my lord, kindly hear me, my lord, for a moment. My lord, what I'm saying, my lord, your lordship has what has fallen from your lordship, my lord, earlier, my lord, I'm going to, my lord, abide by that, my lord, and I will take, my lord,
Mr. Prasad, how will you abide by?
my lord, I will take a written, my lord.
Written will not help. You are the landlord.
Yes.
Suppose I am the tenant. I will tell the court that we will vacate it by 7 days. Today, if there is not vacated after 7 days, what you will say? You will come and tell us that we asked them to vacate, they are not vacating, we are helpless.
Let me that opportunity.
That
my lord.
opportunity was there for more than a year,
But
Mr.
my lord,
Prasad.
I will, my lord, some time, my lord. My lord, I'm not standing on the way, my lord. But my lord, some time should be, my lord. At least, my lord, if not, my lord, 6 months, my lord. My lord, what would be reasonable, my lord? Kindly give a reasonable time, my lord, to vacate and all. So it would be better, my lord. Some reasonable time, my lord, should be, my lord, given.
Did the deputy, Mr. Ghosh, did the deputy commissioner file any report before you, before this court?
No, no report. Because immediate after passing of the order by my lord Mr. Zombita Sinha, then the appeal was taken up. The division bench passed an order. Therefore, my lord, that order was passed by the honorable Singh. Initially, the stay order was granted by the court, division bench. Thereafter, my lord, the court.
No stay was granted.
Actually, possibly, my lord, they
No, no, no. Stay was not granted.
Yes, yes.
Oh, there was a stay. Yes, sorry, Mr.
An order on the
That was passed on 16th of April.
2024.
Thereafter, an order was passed on
30th April 2024.
Right.
An order was passed. And so far as the opposition is concerned, to submit a report. We did it.
the present can number 3 করে দেবে।
Your Lordship, item number 3 and 4. Yes. Your Lordship, item number 3 and 4 are from the same order dated 6th May 2025. There were two writ petitions.
Yes, sir.
Your Lordship, item number 3 and 4, there are two appeals, but from the same order dated 6th May 2025. The reason being there were two writ petitions. One writ petition, we have challenged the amendments of an act under Article 304B, and there is another writ whereby we have challenged the
What do you want, sir? Today, what do you
Your
want?
Lordship, today I want a not today. Your
Why?
Lordship, Mr. Sakusan was supposed to come in court. He has not come because of his personal difficulty. We did a conference last night also.
What is the scope of any interim order?
Your Lordship, any further coercive action because
Writ petition has been dismissed.
yes.
So what coercive action you want?
Your Lordship, any demand because
My lord,
we
may I
have,
tell, my lord,
we
two,
have challenged and
two writ petition. One, my lord, challenging the virus of the statute, West Bengal Agricultural Produce Marketing Act, whereby, my lord, the demand notice was sent time to time. Initially, up to 2012, my lord, they complied with, they filed the return. Thereafter, they stopped, they did not pay. Then, my lord, notice of demand served upon them to pay. More than 1 crore was the notice of demand in 2016. They challenged the same. At the same time, they challenged by another writ petition the virus of the act. Their contention before the court, so far the virus of the act.
They get any interim protection in the writ?
My lord, there was, my lord, so far I know, my lord, initially interim order, thereafter, my lord, there was a direction to pay 50%. So far my knowledge is concerned, my lord, I did not appear at that point of time. Later, at the final stage of hearing, I appeared in one matter where virus was challenged. Then, my lord,
Now, Mr. Sen, then you let us know what is the total dues as on date.
yes, now, my lord, total dues, my lord, I have, my lord, stated the officers, now, my lord, marketing board has not yet, my lord.
I'm right to take instruction and
Well, I shall
you are
take
on
instruction.
the next date, on the next
No,
date,
matter
you
the-
tell us the amount
yes.
due and payable.
Yes, let them secure it, let them pay at least 50% or secure it as
That
per
we
civil
will
procedure code.
consider.
I shall come,
one fact, Your
well,
Lordship,
next week,
subsequently we got
kindly fix
protection
it
from
next
the
week.
writ court whereby
More than 3 crores at the time, for the time being, more than 3 crores, yes. Because that demand was, my lord, 2016 and 12, 13, 15 assessment year or accounting year
but
previous.
after that demand, when we filed a writ, we got a protection from this honorable court. Because we have challenged the
Achha, we can first
Yes,
we
yes,
can
yes.
hear the
But
appeals.
now,
Hear the appeals analogously. There is no problem.
now they, my lord, they failed in the writ petition. Now the statute says, yes, it is right, correct. So now let them pay either
You
pay.
tell us when you can come with the due statement.
Next week, my lord,
Tell us,
1 week, my lord, Wednesday. Next Wednesday. No, no.
Due to appeal, both the appeals have arises out.
My lord, in item number 5, my lord,
তোমার সামনে বসে রয়েছে।
My lord, in item number 5, my lord, I appear on behalf of the respondent, but my lord, led by my lord Jishnu.
In adjournment.
My lord, I am led by Mr. Saha, my lord. He, my lord, for his personal difficulty, my lord, he could not come to court today. My lord, I am praying for 1 day accommodation.
Who is the appellant?
I am for the appellant,
You
madam.
are-
In that case, my fix it on next Wednesday, madam. Because of some personal difficulty.
এটাকে 25th জুন করে দেবে একটা নেক্সট ওয়েডনেসডে করে দেবে। এটা কি আজকে এসছে ফাইলটা? নতুন ফাইল? দেখি কোনো ডিফেক্ট ফিফেক্ট আছে কিনা। দেখো। Exploration of video direction. Next Wednesday.
When I appear on behalf of the petitioner, my lord, and the only thing, my lord, if my lord kindly take it up next week, my lord.
Sir, why do you give the returnable date today? Matters are listed on the basis of the returnable
I-
dates.
And I,
Every day, if you come and say, give me adjournment, you could have given the
My lord,
returnable date later.
but I have, I can place it, but Mr. Mojumdar is leading me in this matter, Shomo Mojumdar. And it is in respect of section 135 of the Electricity Act, wherein the land.
This matter, I am for the respondent, I am paying not today only, my lord.
Next Wednesday, yes.
Grateful.
কোনটায় আমি বসে পেয়েছি বলে কি?
একটা কোনো চেনা মতো আছে। এটা এইটা
Lord, before come to the our case, Lord, how to recapitulate to understand myself, Lord. For my clearance, Lord, or the memory, I like to place the present laws of the matter.
First page the impugned order.
I am unemployed. I will the unmarried daughter.
So, Mr. Vanna, you place the impugned order. You will come to
I am. Impugned order টা বল কর। So at 65, I am placing the order at 65. This is the order impugned in this appeal. Lord, I am placing. Learned counsel for the petitioner contends that the petitioner is an unemployed dependent daughter.
Unmarried.
Unmarried dependent daughter of her father, who was a freedom fighter and was getting freedom fighters pension under the Swatantrata Sainik Samman pension scheme. Learned Counsel contends that the petitioner's application for the said pension was refused by the respondent authorities initially, upon which a repetition was moved. Subsequently, the petitioner's application was considered and was refused on the ground of long lapse of time in making the application after the expiry of the petitioner's father. The other ground cited by the respondent was that the petitioner was regularly employed from 1979 to 2007 till superannuation. It is argued by the learned counsel for the petitioner that it is well settled that the question of limitation has to be looked into liberally by the courts. Learned counsel submits that in a welfare state, the question of limitation cannot be an absolute bar in grant of relief. If the petitioner was otherwise entitled to it in law. Learned counsel submits that in several cases, this court and the Supreme Court has taken a lenient view in such context. It is submitted that the petitioner acted in the Gandhi ashram and earned a paltry honorarium. Learned counsel, additional solicitor general, cites the state of Madhya Pradesh and another versus Bhailal Bhai and others reported in AIR 1964 SC 1006. By placing particular reliance on paragraph 21 of the same, it is argued that the provisions of Limitation Act do not as such apply to the grant of relief under section 226. However, in the maximum period
Mr.
fixed by
Manna, kindly come to paragraph 12.
paragraph,
Reasoning starts, yes.
yes, paragraph clause 52 further stipulates that the application received after 6 months shall be considered by the bank, shall not be considered by the bank, but referred to the ministry, which shall be taken in view whether to allow the dependent pension or not, whether any arrears are to be paid. Clause 6.1.2 indicates that the bank must ensure that a dependent pension is not sanctioned to a spouse or a daughter of a freedom fighter if inter alia the spouse daughter is working in a private sector or having his own her own business activity, then income from such job or activity exceeds rupees 20,000 per month. In the circumstances of the present case, it is found that the petitioner was earning an honorarium from a Gandhi ashram from 1979 to 2007 till her superannuation. It is to be noted that the father of the petitioner expired long back as on February 18, 1996. How the petitioner made her first claim family pension only on July 11, 2007. The inordinate delay of 11 years in between, it is not explained by the petitioner. Moreover, the conduct of the petitioner itself indicates that the reason of the petitioner not claiming pension previously, despite the demise of her father in the year 1996, was her employment, which continued till 2007 when she was superannuated. The coordinate bench, the coincidence is a bit too much in respect of the year when the petitioner was superannuated from her service, and the year when she made an application for family pension, both being in the year 2007. Thus, the petitioner, for all practical purposes, could not be said to be a dependent on her father, who had earned his rights for getting the freedom fighters pension as per his own acts. দেখি যাচ্ছে না দর্শক দেখছেন দর্শক উল্টে গেছেন তো
Mr. Manna, admittedly, the application for pension was made 11 years after the death of
Yes.
the deceased.
Yes.
And during that span of 11 years, you were working in a private concern.
I was earning a
Paltry amount, which may be less than 20,000 also. But question was that dependence issue was not on the
established.
surface, because she was satisfied that I am earning something. Now, on what ground you want us to
Lord, I
interfere with
am,
them?
after going through, I have decided to argue on few points. Lord, I like to say that, Lord, I have concluded 7 points. First point, I like to submit on the point of otherwise eligible. What is the meaning of otherwise eligible in terms of the scheme itself? And then, my Lord, when
Then please show us the scheme.
yeah. So I like to place the scheme first.
Yes, sure.
Yeah, I am coming. Yes. Yes, yes. Lord, Lordship, don't take me otherwise. I have prepared a gist of the argument notes, my Lord, enclosing, my Lord, the schemes for myself. If your Lordship permits, I can hand it over to my Lord.
You a copy.
I am also, sir. I am to submit. Obviously, I am to submit.
You will be placing from this.
Yeah. I will take, my Lord, not to take care and here. Your Lordship kindly.
You have filed a supplementary paper book also.
Supplementary, supplementary affidavit enclose the affidavit and reply that. Not this is a supplementary affidavit.
This one. This one.
Yes, this one. But I have handed
Opposition and very good. Yes.
I have handed over this
All right, Mr. Manna, come to
enclosing the schemes so that my Lord need not go to the main papers and the supplementary paper. Lord, if your Lordships kindly come to page 8 of the branch handed over to my Lord just now.
Yes.
But this is wherein your lordships will find. This is the scheme of 1972, which was
No, what is the scheme under which your case falls?
I'm coming. Kindly bear me for some minutes. Before the scheme, there was a scheme for grant of freedom pension to the freedom fighters. That is the scheme of 1969 for the freedom fighters who were in the cellular jail. Subsequent to that, on the 25th years of independence, the 1972 schemes coming was brought in by the government of India in the name with the nomenclature the freedom fighters pension scheme. Now let us come to the first scheme first, because I like to show before my lord how the first liberation has been done by the government from one step to another.
Accepted, liberalized. We are accepting your context.
Because now that your lordship kindly come to your lordship kindly come to paragraph duration at page 12 of the
Yes.
Your lordship have a look to page 12 of the bunch. Duration. Well, the bunch which I have handed over. Well, I am referring all the documents from the bunch.
Yes.
Yes, page 12, duration. Except in the case of unmarried daughters, the pension is for the lifetime of the recipient. In the case of unmarried daughters, pension ceases immediately after they are married or become otherwise independent. In the case of death of pensioner, the heir of the heirs, though otherwise independent for pension, will not automatically succeed to such a pension. They shall have to apply afresh with proof of death of the pensioner, and their application will be considered in terms of the pension scheme. This was the first scheme, was the freedom petition. I'm asking myself, I am submitting to this effect. The first scheme of 1972 were prescribed for application, but no limitation, no time was ever prescribed. But this scheme was initially issued with a condition that the freedom fighters whose annual income will be less than 5,000, only they will get the pension.
Which
That
one?
72 school was limited to the persons whose annual income was below 5,000.
Where do we find that?
How? Introduction? I intend to place the key. Introduction? My lord, paragraph 3 at page 8. For the purpose of the scheme, the movements for merger of, sorry, my lord, freedom fighters, wait, the maximum pension sanction will be such and such, and 2009, on family of the man.
সেকেন্ড পয়েন্টে রয়েছে
I'm sorry. of the debt. The application, I'm pressing next, the application received after 6 months shall not be considered by the bank, but refer to the ministry. The ministry shall then take a view whether to allow dependent pension or not, whether any areas are to be paid.
This is an application for transfer,
Yes.
not an application for fresh pension.
No, well, it is an application, in fact, it is though. it
No,
is-
what is your stand? Is it a fresh application which you
It is
submitted?
a transfer,
It is a transfer
transfer.
application.
not fresh.
So if it is a transfer application, under the old scheme, what was the provision?
Provisions was, as soon as the father will die, I want to apply.
That will be considered as a fresh case.
Though it has been stated to that effect. But
The scheme provided that unmarried daughter pension will not be stipulated.
Lord, kindly allow me to recapitulate my memory for placing the scheme of 1980 once again.
You will place later. First show your transfer application which you made.
My transfer application is at page, application?
Transfer application.
We have, Lord,
Page 45, sir.
page 45,
42, 42,
42 stars.
Application for transfer. এটা হচ্ছে application, ওখানে বললো এখানে একটু ডাইসি আছে। ওল্ড স্কিমে ছিল না, ওল্ড স্কিমে ছিল যে তোমার এটাকে ফ্রেশ কেস হিসাবে ট্রিট করবে, এক্সেপ্ট দ্যাট অফ ইট আনম্যারিড। যে পেড ডিমান্ড। What is page 12? It starts except in case of unmarried. Pension is for lifetime of in the case of unmarried, year hole that. But in the case of a death of a patient, his heirs, if the heirs will include, will not automatically satisfy them, they shall have to apply afresh, which their application will be considered. But there is no provision of এই যে লিমিটেশনটা আনছে, that is page 1.
One thing I could not know,
That is in respect of a transfer.
ব্যাংকের কাছে কোনো চিঠিটা পাচ্ছি না আমরা।
After death of the pensioner, the transfer of pension will only be considered. এখন তার মানে কি এটাকে ট্রিট করা হচ্ছে as
এখানে
fresh
প্যারাগ্রাফ দেখো,
application?
এতে লাস্ট পার্ট ওয়ান প্যারাগ্রাফে বলেছি কেন
কেননা
রিপোর্ট
সেইখানে
ব্যাংকের কাছে করেছি।
applicationটা received after 6 months shall not be considered by the bank, but
হচ্ছে সাধারণত অ্যাপ্লাই অফ পেনশনটা কি
they have to apply.
ফ্রেশ পেনশন
Transfer.
ট্রান্সফার দ্যাট তো বলে
Transfer to me. Transfer কথাটার means. Yes,
in this application at page 42, so my client category written, but that she could not hand over the copy of the application which she made to the bank. No, here she says, after the death of my father on
Page 42.
18/96,
page 42.
42, my lord, first, second, third paragraph. Third paragraph,
2, 42.
42, of the paper book, my lord.
Page 42 is
42.
A, 42A.
Oh, sorry, my lord, it is a type copy. And the original is 42.
Yes, which paragraph you are saying?
Because paragraph starts after the death of my father. After the death of my father on 18/96, I paid to the paying bank in the to pay monthly pension in my favor as I was entitled to enjoy the same. But the authority of the paying bank did not act according to the rules of payment of family pension.
When did you make that happen?
Lord, that I cannot say. Well, I cannot enlighten. It has been written by the client.
You
But
have
no-
you have written.
No, no. Well, I'm because what happened that too. I'm to take my lord. Lord, that copy has not been given. I cannot mislead my lord. But I can will show. She has stated so.
So where
After you also can come to page number 46 for a moment. They acted upon that. The audit officer, 46. 46, the audit officer referred that letter with a note. Typed copy is at page 46A. 46 is quite heavy, so I have typed it.
yes.
The Government of India, Ministry of Home Affairs, New Delhi, in their letter dated such and such, that is, 17/8/74, was sanctioned SS pension at the rate of 150 per month to Sri Krishnapada Bera, my father, of district Midnapur, West Bengal, and consequently PPO number such and such was issued in favor of Sri Bera for payment of SS pension from the treasury of Midnapur. Now his daughter, Kumari Sadhana Bera, by a letter dated 11/7/2007, addressed to the ministry with a copy to this office, reported that her father, Krishnapada Bera, expired on such and such, and claimed for payment of SS pension, family pension, with arrears. As the claim has been made after lapse of 6 years, neither the pension disbursing officer can arrange payment, nor this office can advise the pension disbursing officer for arranging payment of SSS dependent family pension to Kumari Bera automatically as per government instruction at circular number 8 of such and such dated 1992. That is of which I showed at page 92 circular. With respect to the sanction of the without the receipt of sanction as required under Rule 369(4), it is therefore requested.
Acha, why it is said 6 years? It will be 11 years, na? Preceding as the claim has been made after lapse of more than 6 years. Very good. Then which document?
That was done nothing. After that, I wrote my letter, nothing was done. Ultimately, I had to come before this honorable court in a writ application.
Yes.
Lord, your lordship will find that writ application of 2009 at page number
52. 52.
48 starts, relevant portion of the order is 52. Yeah, I'm placing there.
Relevant portion.
Relevant portion. For the reasons I regency views are there before prior to that. Concluding para is for the reasons I dispose of the petition ordering as follows. Within 6 weeks from the date of communication of this order, the Government of India shall decide the petitioner's claim for SS dependent family pension in the light of the things said in the letter of the audit officer, Pen/TRG Cell, Indian Audit and Accounts Department of the Office of the Principal Director of Audit, Central Government of Calcutta. The decision shall be communicated to the petitioner immediately, and if it is found that the petitioner is entitled to SS pension, family pension, then the steps for payment shall be taken without any delay.
Yes, now page 56.
Next, 56. 56, the order was asked by the Deputy Secretary rejecting my claim. On the ground, they have stated everything, and ultimately they have stated a relevant portion at page 53, your lordship kindly paragraph 57, Willard, paragraph 3, Roman I, that the powers relating to the transfer dependent family pension to the eligible dependents of the deceased freedom fighters have been delegated to the concerned pension disbursing authority, the public sector bank, government treasuries, etc. Void ministry's letter dated of 92. But family pension stating that you have claimed
But the audit refused to pay. But the
the audit officer such and such refused to pay family pension.
Where is this 1592 circular?
92 circular, sir. 92.
Okay, 92,
91
sir.
No, please only tell us the page referred to in paragraph Roman 1,
Roman 1.
page 24.
সার্কুলারটা কি নিয়ে দিচ্ছিল আমাদের করা হয়নি 91টা করা আছে
92 দিয়ে ওই যে
সার্কুলারটা এসেছিল সেই সার্কুলারটা প্রবলেম হচ্ছে
That is page 24 of your
page 24
of the note which you have handed
yes,
over.
page 24. Page 24.
72
Yes, yes, continue.
এটা না এটা না রাখতে যেটা আপনি যেটা পয়েন্টটা পয়েন্ট প্লাস 7টা পয়েন্ট যেটা আছে স্যার 7টা পয়েন্ট ওটা পেশ করব
It is this circular which has been referred.
Yes, yes. 115.
Yes, this is the circular.
This is unmarried.
57.
Unemployed. As per SSC scheme of next page.
যে অলকার বিক্রিয়াটা কোথায় তো পারতো
1983 আনুমানিক কথাটা কি ছিল কি
ছিল
আর unemployed 1980 স্কিমটা Clause 2 you are reading. Page 57.
57. No, your lordship.
As per SSC scheme of 1980, only unmarried and unemployed daughters of freedom
Yes.
fighters are eligible.
Yes. And as per your certificate and DIB's report, you were regularly employed since 1979 to 2007 till superannuation. This was one of the ground for it has been rejected. Another ground, in response to the ministry's letter of event number dated 5/1/2011, asking circumstances not informing about demise of your father, delayed, waited 11 years for claiming dependent family pension, you have replied by your letter dated 31st January 2011 that paying bank was informed, and when this bank asked for the copy of your letter, you replied vaguely. But here also my client, before coming to the court, he replied, I went to the bank, I submitted the document. No, it is January 2011.
Clause 3,
Clause 3, letter of 5th January 2011. That is similar to 2011. So that has not been annexed.
very good, you proceed. Then what happened? Then this order you challenge.
Kindly excuse me, I like to place the paragraph Roman 4 also. As stated in paragraph C1, Roman 1 and C Roman 2 above, you were employed as teacher, hence did not claim dependent family pension till superannuation on 31st March 2007 and informed the state treasury only on 11th of July 2007 that you are unmarried and unemployed daughter of such and such. In view of the above reason, it is regretted that your claim for sanction such and such. Then I had to come.
You challenge this order.
This my lord, I challenge it, my lord. Lord, after that, I made representations taking reconsideration that such and such I don't have the income above the 20,000 per month. I am to ignore. I have annexed those representations
Yes.
also.
Now the writ court passed the order. Page 63.
Page 6.
Yes, then what is your argument, Mr. Manna?
Milord, here, when Milord, the writ court directed the concerned authorities to consider the case. Milord, according to my submission, I would like to submit that the writ court has condoned the delay of filing the application, as I understand. Milord, because I will take to that effect also. Milord, as the writ court has accepted the writ petition and passed an order directing the concerned authorities to consider my representation in obviously in accordance with law, then Milord, I believe Milord, the court has Milord considered the point of limitation and condoned the delay.
Yes.
But in the similar circumstances, I like to place another case at page number 210.
No, sir, main paper.
Page 210.
Okay. Your Lordship kindly have back to that. Your Lordship kindly come to page number 206. Representation dated. Representation just 2006 bottom. representation dated nil by the petitioner paying for granting pension.
Hmm.
Here, the petitioner did not make even a single application. There, his father died in the year 2080. Back to that, mother died. After the death of the father, pension was sanctioned. In this case, thereafter, only in 2007, she moved and a writ application before the Honorable Court. In the writ court, order was passed at 2009. 2009.
209 page.
200, sorry, my lord. I have started 2000, 209.
Page.
At page 209. This is the order. I have heard the learned advocates appearing for the petitioner, and after considering the facts of this case, I direct the respondent authority to consider the case of the petitioner by treating this writ petition as a representation and consider in accordance with law.
Next, 10, 11. Representation. Did it? Where did you read? Page
Page 209.
209.
200?
209 of the paper book. Main paper.
This is of a different matter.
Similar
16737.
Similar
Page
Right, this is
209.
another matter. I am telling you the similar case. I am testing with a similar case.
So how similar case will
No, I am coming because how the direction for consideration condone the delay. To that effect, I am referring this matter.
where it is condoned?
Because in 1980, his father died before sanction.
Where from you are getting these facts?
orderটা পড়ে দেন।
If I will take my lord to that effect, my lord kindly accept me for the timing. I will satisfy in every hour.
Where you will satisfy? You are showing us 209.
Yes.
And you are saying that this direction means
No, I am
that limitation condoned.
May not kindly have a give me one minute time. I will satisfy that what I am saying that will be reflected from their letter.
All right.
Right. But here I am stating the father before the death of father, mother died.
Acha, you will show us when you come to that point. Your argument is that in view of this order, limitation stands condoned.
Done. Like here also in the other case at page number 209, there even Miller 20 plus 27 years delay was condoned on the basis of the direction of the High Court. But they did not
Next, Mr. Manna, please proceed on the next point.
Yes, I am coming. On the basis of that rejection, a writ application was moved. What has been held by the writ court in the matter about the limitation, also the applicability of the 214 guideline. So I am referring this judgment to satisfy my lord.
We understood. You proceed.
Sorry, ma'am. Lord, your worship kindly have a pen to come page number 212, paragraph. So I am placing paragraph 6, 7, first. The respondent contended that as per the SSS scheme, the petitioner is entitled to get pension only from the date of the application. Better, I think.
You did not place this order before the court? You did not place this order before the single judge? This page 212 order, did you show it to Justice Bhattacharya?
That is the subsequent order. After passing the order in my case, here, instant case, this matter was.
All right, which paragraph you are saying?
Lord, better I should read the entire judgment.
No, but we will read it. You show us which portion. You are not arguing. You are showing us only paragraph after paragraph.
Paragraph 6. Respondent contended as per SSS scheme, the petitioner is entitled to get pension only from the date of her application and not from the demise of the freedom fighters. There cannot be any doubt in that regard, since the respondent have correctly relied on clause 5.2.2 of the relevant scheme, which is in no certain terms stipulates that the dependent pension shall be paid from the date of the application by the spouse stroke daughter and not from the date of death of the pensioner. That despite such the dispute arises, which arises here, is as to the date of the application of the petitioner. The original purported application of the petitioner of 2007 cannot be produced by the petitioner and thus cannot be relied upon. The stand of the respondent is that the first order dated April 23, 2008 in WP number such and such had culminated in a rejection of the petitioner's application due to the laches on the part of the petitioner in not producing any supporting document. Hence, the said representation cannot according
This
to
is for the purpose of giving effect to the date of pension.
pension.
This
And
is that whether it will be from the date of application or from the other date when court passed the order. It has no relevance with your matter.
Here, why I am referring,
Mr. Manna, if you want to unnecessarily drag on Mr. Manna, we are sorry.
I could not follow, my lord.
You have been able to follow. You are trying to show us an order which was not before the single judge. Moreover, this order has nothing to do with your matter because your matter is belated application.
Yes.
Here the case was application was made. It will be from the pension will be from date of that application or from the date of the order of the High Court.
There was also a belated application because father died.
Where from? Belated application was that issue decided?
It has been said. No, your lordship kindly take the.
Why should I take? You tell us that that point has been decided here. Show us that this point, this delay point has been decided. That once High Court has previously said considered, that means delay condoned. Where it is said, where is that line?
Because on the point of that, because they have sanctioned.
They have sanctioned.
And in the sanction order, they have stated father died 80.
Very good, very good. We have access now. What is your next argument? Finish.
Next argument is
anything else?
যেটা দিল যেটা আমাদের জাজমেন্টের পরের সপ্তাহে যেটা হলো
Mr. Manna, just because we are hearing you, you should not. We are giving you every possibility to assist you. Now, if you take that advantage and continue for 3 hours, we can never finish our matters.
I'm coming straight to that point. Your lordship kindly take pen to page B1. But I am here, I am referring to this point as to whether the applicability of the scheme, applicability of the application, and delay on the point of delay also. Well, I am referring to one judgment of this court which has been passed and accepted, and they have complied with the order. Your lordship kindly take pen to come paragraph 18. Paragraph 18 of this judgment.
Now you will show us all matters. You are not addressing on the point we want to know. We have to bear with you now. You will submit this matter kindly see, this matter kindly see. Mr. Manna, you also know that that judgment is not ready. Anyway, we are, yes, which paragraph you are saying?
Your paragraph 18. Paragraph 18 of the এটা তো It has been rightly contended by the petitioner that state guideline means the guideline of 14 issued subsequent to the scheme by the concerned ministry. Miller, has your lordship got Miller paragraph?
Yes, we are reading.
Sorry, Miller, I could not. Ministry to the authorized public sector bank do not form a corrigendum or an amendment to the original pension scheme, which still remains intact. Then paragraph 19. In fact, the modalities as stipulated in the said guideline can at best pertain to procedural nuisance of the disbursal under the scheme and cannot affect any substantive right conferred upon a person under the scheme, read in conjunction with the concerned law governing in the field. Then you also kindly see, I'm placing 2-3 paragraphs more. Paragraph then 20. Clause 5.2.2, which stipulates that the dependent pension shall be paid from the date of the application by the spouse or daughter and not from the date of the death of the pensioner, is not a sacrosanct as sought to be projected by the respondent authorities. Then your lordship kindly,
then you read this with 5.2. This is on a totally different subject you are referring. This is a question of grant of arrears, whether it will be from the date of the death or from the date of the application. You are showing us that this relates
next
to
paragraph also says this is not at all applicable. This judgment also says that there is no limitation, because I am coming that also, my lord.
Limitation for what purpose? For the
For
question of
application.
arrears.
For application, my lord. Sorry, this judgment says for application. There cannot, my lord, the eligibility starts on the death of the date. That comes as soon as the application is made. That has been stated, my lord. Paragraph, your lordship kindly allow me to place 3 paragraphs more of this judgment. 35, 39 and 40. Lord, kindly allow me, Lord. 35 states, to shed light on the issue at hand, one has to look into the scheme itself. Has your lordship got me? It is evident, paragraph 35, it is evident from the relevant clause, that is clause 12 of the scheme, that the same is only indicator which pertains to the issue of hand, although somewhat in an oblique manner. The exact expression used in clause 12 is as follows. In the case of the death of the pensioner, his or her heirs, though otherwise eligible for pension, will not automatically succeed to such a pension.
Mr. Manna, show us that delay stands condoned since High Court directed. Show us from this order.
I am saying that there is no delay because scheme has not prescribed any delay. That has been considered here. This judgment considered there cannot be a delay because scheme has not prescribed any delay.
Come to paragraph 39. Paragraph 39 of that judgment.
39. I may be wrong in my understanding. Lord, I am trying to convince my lord, but I may be wrong.
We have enormous patience, Mr. Manna.
Yes, I know, my lord.
We could have thrown you out at the first sitting.
My lord, kindly Your lordship has given enough time. Kindly allow me 2 minutes time to
You
place
are
paragraph
taking,
39.
you are, since we are giving you opportunity, you are taking.
My lord, here these two paragraph, my answer will be within these two paragraphs. Thus, the consideration at hand would be in the light of the pension scheme, that is the 1980 scheme. More particularly in terms of clause 12 thereof, the expression otherwise eligible for pension in the said clause clearly clinches beyond all reasonable doubt that the eligibility otherwise accrues in favor of the heir of the petitioners immediately upon the death of the pensioner.
No dispute.
Yes, no dispute. And coming then-
No, read that last
Read
bit.
last line.
Subject.
Subject, however, to an application being filed within a period as prescribed therein.
Correct.
What does it mean?
Yes, I admit. I admit. Then your lordship kindly come to paragraph 40.
আবার বলে
Paragraph 40. Paragraph 40.
কি করবো আমি?
Paragraph 40. Once an application is filed, the eligibility reverts back to the date of demise.
No problem. Yes. But here you made a belated application after 11 years.
I am asking myself.
You go on asking yourself.
No, I understand. I am
So,
asking myself.
The
Sir,
president.
is there anywhere in the scheme within certain time I am to apply? Well, I am asking myself, my lord. Anywhere in the scheme?
We will say it in our judgment, Mr. One.
My lord got every time.
যে জাজমেন্টের উপরে সিঙ্গেল বেঞ্চ রিলাই করেছে সেই জাজমেন্টটা এখানে তো সেটা ওভাররুলড হয়ে গেছে ভাইলাল ভাই হ্যাজ বিন ওভাররুলড বাই সাবসিকুয়েন্ট জাজমেন্ট
আরে সেটা তো মানুষের কথা বলেছে
বাট স্টিল দ্যাট হ্যাজ বিন রিলাইড অন and sir our application 2007
that too, my lord, my application is 2007. As guideline cannot applicable, it is of 14.
So any further point you have?
No,
Finish
I will not disturb, my lord.
No, not a question of disturbing.
But
It's your right to argue.
according to my understanding, nowhere of the scheme there is a time limit prescribed. I am to place. As soon as I will apply, that will revert back to the date of the day.
President has concluded his argument. Is the matter for further consideration. What we take Thirtieth June. Yes. Take it.
Your Lordship, the next matter, item number 9, Your Lordship, Mr. Anindo Kumar Mitra is appearing in this matter for the appellate, Your Lordship, but he has not come to court. I have spoken with the Mr. Tonay Chakraborty, who is assisting the learned Advocate General.
He had only to adjourn.
Kindly, Your
Anytime
Lordship,
you
could
entered
fix
the
it
court,
on
make a
25th of June because the learned
May I please?
My lord, I'm sorry, my lord. Item 14, my lord, Mr. Chidambaram was here. After this matter, if that could be taken up, my lord. Item 14, 12, my lord.
This will continue for some time.
At 3:30, probably there's a original side. 3:30, my lords have a original side.
No, original side, whether we will take up or not depends upon completion of this matter.
We'll wait, my lord, after this matter. My lord.
There is very less possibility because Mr. Chidambaram, it was not mentioned that you would be coming. We could have fixed a date, and it was not mentioned beforehand. No, not at any time.
But time. Chief Justice. My lord, my lord, we had mentioned before vacation, my lord, because
So
this
you
was.
should have told us that list.
Both of
My
us had
lord,
talked,
I had appeared for Reserve Bank of India where I had indicated that I was led by Mr. Gupta in the matter.
Mr. We cannot assure you, no, this matter it has started, he has just started his argument. You agree to a date on
My
the
lord,
date.
that's what on the last occasion I had
agreeable to
indicated.
any date fixed by your lordship, so that we can come back on that.
My lord, I had indicated that my senior was in difficulty because he's traveling. So I had indicated and requested your lordship to keep the matter, make it returnable in the month of July. Your lordship was keen on taking it up today. So that's why it has come up today in the list. But if your lordship would be kind enough.
Keenness for any matter.
Yes, sir.
I was not
Lordship
even
would be
aware.
We are
kind
never
enough.
keen.
No, but your
We
lordship would be
proceed
kind
as
enough
if we
to
have
keep
then
it
when
on.
it appears to you, we are keen, we are releasing the matter.
No,
No, not like that. Your lordship would not take me amiss.
Better use your words in a
Yes,
proper manner.
your lordship should not take me
You
amiss.
should
my
never
lord.
submit.
What I wanted to make my submission on
Why
was-
should the court be keen to take
No,
on
your
its own?
lordship, I had indicated, and at the instance of the petitioner, the matter was kept today. It was made returnable today because they said that they wish to get their stay application heard. So that was
We
the
did
ground.
not make it returnable. It was mentioned, we
Yes.
kept it today.
Today.
There neither any keenness nor any effort on
Very
our
well.
part
Your
to keep
lordship,
it on our part.
I apologize on my part, my lord, but
You should apologize.
yes, your lordship,
This is
and
not the way of making submissions before the
I'm sorry, my lord, but your lordship will be kind enough to keep it in the monthly list of July if it's possible. Otherwise, your lordship would keep it on any other day.
You agree to a date and tell us.
আমার কোনো অসুবিধা নেই, any day, any day. I was
You
not
agree
aware.
to a date, Mr. Chidambaram, and tell us.
I was not aware of that mention.
But the thing is, we do not want to keep you waiting unnecessarily because if the matter is ultimately not taken up, because this matter was continuous, had it been mentioned to us that yes, you agree on a date and tell us. Tell us.
1st July, will it help you?
6 to 9.
My
No, you discuss a date with us and let us know. Yes, Mr. Sannal.
6 to 9th of July.
আমার কোনোটাই অসুবিধা নেই।
Yes, Mr. Sannal.
Yes.
Now, should we indicate that date to the learned court master?
No, you settle it and tell us. Then
Yes.
we will.
Your lordship is.
No, my lord, I placed with your lordships yesterday.
You fix a date 1 week after next week from 23rd onwards. You fix it. Yes.
My lord, yesterday I placed with your lordship the first order of the commission, and then I had taken up your lordship certain documents that the intimation or intimation or communication between the COMOH and the my lord, nursing home, the petitioner before your appellant petition before your lordships. Now, my lord, pursuant to your lordship's direction, my learned friend has favored me with a bunch of documents, but without any report. I do not
Yes.
find any.
You were at page 105, the show cause.
105.
Page number 5. Page number 4.
Now, Malad, this is updated 24th July 2020.
Communication to the CMOH is 101. You placed it.
Before that also, your lordships, I just
101 was to the CMOH.
then I just take your lordships, the other one.
9 was to the officer in charge.
And your lordship, page 98 also.
Yes, 98 was
Also
to the,
CMH.
that was not the that was the first representation.
Exactly. From
Yes.
our side. Now,
Yes.
this Malad gives Malad.
This show cause was after you replied to page 98.
After reply to page 98.
Hmm.
Now, all that I'm saying, your losses, page 98 gives a light and deals with the first point of the show cause. Because your losses, to an extent, I tell your losses why. Kindly see, you could not, page 105, first show cause letter point,
Yes.
you could not produce any evidence of medical intervention for stabilizing the patient.
Yes.
Now, kindly have a look at 98, then I will go to Malad, page 106.
Yes, 98.
Point 2. On arrival, the patient observed to be in a very serious condition and required ICU care. 3. On that instance, there was no vacancy for critical care bed.
Yes.
5. We have tried for screening the patient for our isolation ward admission protocol for the benefit of patient. So, if I cannot have the bed, how could I do medical intervention? Then your losses kindly, anyhow, show cause later. Page 106. The point 1. A. The patient being referred by ESI hospital comes with the referral quotations with an advice of ICU ventilation for each patient as usual. And there was no difference in the case of patient named Subhrojit Chattopadhyay. The said patient has already been stabilized in ESI hospital and has come in full support and guidance of ESI hospital Kamarhati. And on being informed by us regarding non-availability of bed, the said patient been summoned back by ESI authority without delay. For this reason, and so we are not authorized to conduct any medical intervention, and so we are not able to provide any evidence of the same to your investigating authority. Next page. The undersigned has already stated that for this particular case, as a special case, checked a COVID kit in discussion with ESI Hospital, Kamarati, and the visual understanding of COVID kit only been shared with ESI Hospital, Kamarati, and the same done for the benefit of patient. Undersigned has also stated that we are not using COVID kit for a single case other than this. We are doing RT-PCR test only for detection of infection in collaboration with government-approved center. We have submitted documents for evidence. Undersigned once again humble request you to take in consideration that the institute in working in support of ESI Hospital, a government institute, and had been giving treatment to lot of patients with COVID-19 suspect and not refusing any patient in our limited resources. This is to request is to consider the matter, and as we are bound to follow directives of ESI authority regarding treating their patients, the institute needs to consideration all that. Malad, my endeavor to take your losses to all these communications, that these were the communications of with CMOH authority officer, Malad, chief medical officer.
Yes,
Even before the preliminary order passed by the commission.
that is at page 87.
87. Now, commission asked for a report of the ESI as chief medical officer. In between all these communications taking place, where is that report, Mala? There is no report at all. Without the report, Malad, the commission finalized the interim order. One thing I tell you, I must tell you, losses. Commission also directed me to take file an affidavit, apart from calling for report. We physically appearing said that we didn't have any bed. That's why I could not. The commission has recorded, this is the first time you are making these submissions. Well, there are 3 occasions commission took up the matter. But I failed to understand when this was taken up for the, even for final hearing on 3rd occasion. That your submission at this stage cannot be accepted. That's the commission record. I will take your loss if the
What would you like? You can ask them to wait. We will keep it on 8th at 2 p.m.
At 2 p.m. Deep your best.
You come and finish it off.
Deep your best.
reply, no step further I find. Therefore, it can be presumed that the COMH was satisfied with our reply to the show cause. No further step by the COMH. On the contrary, my lord, before the commission, the COMH, I do not find that any report was filed by the COMH. In the record, I do not find no reference to that. Only on the basis of the, my lord, whatever submitted by the petitioner's complaint letter, that was accepted and I was held to be guilty.
Yes.
My lord, I take your losses now to the final order of the commission. That's at page your losses 72.
Yes.
Now, your losses will find this is an order dated.
The relevant portion, Mr. Sharma.
I just that I will. Well, kindly take note of the date. May 22nd, 2023. Lord, all the pages right from 87 to 106 of this petition are much of earlier date. Now your losses will find page 75. Matlab, that's the hearing, my lord, hearing took place. Now you'll see page 76, the finding portion.
Yes.
We are prima facie of the view that the clinical establishment failed in their duty in giving at least preliminary medical aid that they denied to the patient.
Yes.
We are prima facie of the view that the clinical established failed in their duty in giving at least preliminary medical aid that they denied to the patient. This is your lordship. This is the initial order that was quoted in the final order. Then you'll, I'm conscious of that. Now your losses kindly come to page 83. Our view, the commission's view. Our under the heading our view. We have considered the rival contentions. Has the lordship got that? The fact remains the patient went to the CE page running page 83, my lord.
83.
Yes, that's a continuation of the final order of the commission.
Yes.
Our view, we have considered the rival contentions. The fact remains the patient went to the CE being referred by Kamarhati ESI hospital. When the patient reached the CE, it was bounden duty of CE to examine the patient in the emergency. The fact that the patient was not allowed to go inside is not in dispute. However, we would just hence, just a minute, madam. Page 83. The CE would only dispute the COVID positive report. Even if we give full credence to the same, we would find no plausible explanation that the CE could offer refusing to examine and admit the patient. The plea of absence of was taken for the first time at the final hearing on March 15, 2021. Kindly consider, my lord, my first COMH letter to at page 98. Why I'm saying what is the report of the COMH? That was dated, your lordships, 12th July 2020, just 2 days after the incident. Page 98.
Page 98 was placed before the
No, before the learned single judge, this was there.
commission.
Not the commission.
No, you had not placed it.
Physically we appeared. That's not the point. We submitted that we didn't have any bed at all for ICU.
Then why didn't you submit these papers?
No, that's one thing, my lord. That's why, my lord, because this was changed series of communication, because COMH was inquiring, we thought COMH will place it.
You have to, you should have.
That we could have. But we verbally made these submissions. But the commission could have, my lord, given a 1 day's time, produce that document you did not have. Why is that? Hari, my lord, to give me.
Issue is that on the you denied preliminary to take. It is a normal human feeling that when a person he should not be left on the road. At least somebody should visited him.
My lord,
it is only after the police complaint was made, complaint was intimated to you, then you came running and conducted the COVID.
My lord, that's their version.
No, there is no other version.
I will take your lawsuit. This
show us that your version, justice, the tribunal, your argument had been that what we could have understood, that what was the hurry? I am not running away. At the prima facie stage, you are saying that our medical college we cannot get within our ambit, so you are catching me. I am before you. 5 lakhs punish this direction. There was no requirement because I was appearing, I was contesting.
That's a preliminary order.
Preliminary order. Now you say that CMOH was asked to submit a report.
That's why.
Suppose report for what? Issue of testing of COVID.
No.
Yes,
I take your loss.
because you conducted PTC
That's not the,
RTKs.
if I'm not wrong, that's not the report called for. Report called for what happened on that day. If your losses kindly come to that page 87.
Happened is that you did not immediately give treatment to the person.
Malad, I tell you losses. ESI hospital with a specific direction directed us to admit at ICU with full support. But how do I proceed with the patient if I do not have a bed? Immediately remanded the matter back.
Mr. Sannal, they could have been approached. They could have, instead of keeping him on the road, you could have taken
Malad, I tell you losses.
some human gesture has to be
Malad,
there.
I tell you losses. This is not with the bay. He was in the well-furnished Malad ambulance. Malad, before that, what we have to do? But we have our serious patients. We have to take a decision. Your losses, kindly do not forget the period. Entire thing was during the COVID period, when this was in peak.
All right, next page 83 you are showing us.
And I was not your losses the COVID, then your losses will find.
To examine and add, pertinent to note, plea of vacancy was
taken for the first time.
But that was there in your reply.
In the reply to the COMH, because before the commission proceeded, COMH proceeded. I don't know for the reason, I do not find any reason. Your losses take once again page 98, your losses will find it.
This 12th July letter was never produced to the tribunal.
That's why I'm finding the commission.
Why didn't you place it on the date of the
that's why my submission was that. Everybody was busy with COVID during that time. Everybody.
Did you file the affidavit called?
No, that's what I'm saying, not the affidavit also. That's your loss. Your lordships kindly say the three orders date. In the meantime, because from the very first day you are slapped with 5 lakhs, my client came before this honorable court. This honorable court stayed that payment. Therefore, the matter hanged. So in between, my lord, again after the disposal of the deed.
Stay was after the interim order was passed. 5 lakhs you deposit. Against that order, you preferred the distribution application. Now the entire proceeding was stayed. Then ultimately stay was
disposed of with a direction to the commission, dispose it off. On the first day, commission said you have not filed any reply.
But by that time, Mr. Sannal, was it not incumbent to file an evidence?
This is one way of looking into it. But what remains on record? 10th
Your
incident
contention
happened.
is this was on record. Please show us that this was on record.
Which one?
Before the commission.
This was not. That's why I'm saying your losses. Then your losses 10th incident happened. This was of later of 12 after 2 days to the COMH.
Yes.
Report was called for first from the COMH.
When was the final order passed? This
final order passed on losses 22nd May 2023.
22nd May 2023, and the interim order was passed on
10th September 2020.
20. Within 3 years, you did not feel it.
I tell you losses. That's your losses. That's one because of the intervening period. The Honorable High Court was moved, certain order was passed, and that's
all right. Yes,
but your losses kindly take into consideration what is the negligence part actually. That your loss is taken to. What is that finding, that negligence part? This is your loss is the only finding, page 83 bottom and 84 top. This is the only finding. Now, ESI hospital didn't carry out any COVID test. They state, I will take your losses to the documents all.
Yes.
Now your losses kindly once again, page 83. Our view, second line. When the patient reached the CE, it was bounden duty of the CE to examine the patient in the emergency. At that point of time, always it was the almost become a regular order.
Yes.
Regular order that the patient has to be sure that whether he is suffering from COVID or not. This was almost everyone. He was suffering from high blood sugar. a boy of 18. So this was one of the criteria of comorbidity with breathlessness. That was the ESI report. That's prompted the authority of the nursing home that first to be checked up his position in regard to COVID.
Yes, next, Mr. Sharma.
Then your losses will find this plea of vacancy, according to me,
was not considered.
They could have been, show your document, the commission could have said, produce your records, because I have shown your losses, all the patients' names at page 124 in the IC, if I'm not wrong.
23 interim order was passed on 22nd.
Yes.
Can you see these were all the patients list? 10th, 7th, your losses will find.
Yes.
Occupancy.
So now take us to the order into how the judge dealt with that.
I'm a single judge.
Yes.
Single judge proceeded because nothing was there before the single judge.
Nothing was.
These things were there, my lord. Before the single judge, your lordships.
These communications were not there.
Yes, these communications were there.
So you should was the wrong in the order.
I adjust. My first,
your first day you made an argument that once you impose a compensation of a cost upon us, that impinges upon our reputation. This was one subject. Next is that there was no finding of negligence. Supported by that, you have drawn our attention to show cause. Now show us how the learned judge has dealt with it. Or if you want to show any other document.
No, first, my lord, we came up before lawsuits questioning the order of the commission. So, my lord, that's why I'm saying, my lord, ultimately, because
this final order was challenged before the writ court. Yes.
So now, how the learned single judge has dealt with your losses can be considered.
And you filed opposition before the trial court, before the writ court, affidavits were exchanged.
No. Report was filed by the medical college. I will take your losses.
All right. Yes.
So before that, your losses, kindly have a look at the report of the medical college.
No, you take us to the order now, Mr.
Because that doesn't reflect.
Report.
Your losses, can have a look at that page 144. Not the entirety of your losses, look into it. Page 145, paragraph 5.
Paragraph 5.
5. Kindly, we are all layman, but we have suffered somehow or other during the COVID period. Kindly see the symptoms. As per records, the patient, 18 years male, came at emergency on 10th July at 3:39 p.m. with a case of fever, cough, shortness of breath. These 3 items your law criteria. But anybody will be astonished that this is a case of COVID. PM SpO2 80%. We used to within half an hour to check with the nozzle that how much oxygen I have in my blood. Kindly see that 80%. COVID positive, because we give him a slip that you are COVID positive. Now, the patient admitted at 3:50 p.m. At around 4 p.m., the patient was unconscious, general condition very poor, not arousable. PR 30, BP 90 by 60. Kindly see. SPO 84%. Oxygen 10, 1 liter. Oxygen was given. Then your lordship, 6 p.m. Then your loss is 7:30 p.m. Kindly see the data only. And then next page, your lordships, 147.
Yes.
That around 9:45 p.m. on 10th July 2020, SpO2, PR, BP could not be measured. Pupil fixed of this patient. The patient declared dead at 9:40 p.m. on 10th July, with the cause of death being metabolic acidosis in CODAK in type 1 MD, patient having COVID-19 illness. This was the finding of medical college also.
Yes.
So this is the report of the medical college before the writ court. So no report before the commission. Now your losses can look at page, my lord, 151. Fever, cough, SOB, blood pressure, such and such, SpO2 80. I have placed it before paragraph 5, that one. So, my lord, one can say when we are admitted with the report of COVID positive hours, but when you say this diet having COVID illness, that's not only on the basis of my report. This is your finding also. Am I clear to your lordships? When you got admitted by the medical college, you had taken my records along with ESI, whatever. I will take your lordship, the ESI, I have got it today. That you can say that because of your report, I have noted.
So your argument is paragraph 15. This is a finding on the part of the medical,
Medical.
college also that he was suffering from COVID-19.
Now, before my lord going to the final judgment, my lord kindly come to the affidavit in opposition my learned friend used. Take a copy now. Because they would jump up and try to point out to your lordships to this. Wait, page ta dekhao jekhane ওই রিপোর্টটা দাও নেই তো ফোল্ড করে রাখো না my lord kindly take up this document. I will only show your lordships the only one page. I will not show much. Page 36 of the affidavit in opposition of Mr. Chatterjee's client. They have filed probably your lordship before lordships. But kindly see, this is at the top left hand side, reporting date 17th July 2020. As you also got the from Mrs. Mitra, page 36 of the affidavit in opposition of the.
So page 95. 17 July
2020.
Yes.
Reporting date. The patient died 10th July. I'm coming to that, your lordships. This is for the first time coming up before your lordships. Not before any authority I have, at least I have seen. Now, therefore, your lordships, kindly see specimen ID number such and such, date and time of receipt 16th July. After 6 days, it might be negative automatically. How did you preserve it? For 6 days, patient died on 10th.
So this test was reporting ID. They tested for COVID. And it was found negative.
Negative. But after 7 days, kindly see when
that plasma is taken.
I believe
Plasma.
I think either from the nose or from the cover.
Huh?
Now, what I'm trying to point out, first, don't believe me.
So is it their case that he was not? It was their case that he was not suffering from COVID.
Now,
but still you did not admit.
This now this is their case that he was not at all died of COVID. He was nobody died of COVID only.
Comorbidity.
Comorbidity. He was the hyper sugar patient.
Yes.
Now your losses. One thing I'm trying to point out. Don't believe me. Take out from any sources. If a report, blood report, whatever report, the sample date and collection will be mentioned. Would your losses get it from here? When the sample was collected. If I go by date and time of 16 July. After 6 days, sample collected. Or sample was preserved for somewhere. These had to be gone into by the commission. Before taking me as a negligent.
Mr. Sannal, please correct us. the tribunal, from the order it appears, the commission proceeded on the basis that when you were having a tie-up with ESI has sent the patient to you. Why didn't you immediately attend the patient? COVID, non-COVID, forget it.
I attended, but I tell you.
This, Mr. Sannal, subject to correction, this factual issue has not been established by you. Why? Because maybe you did not file an affidavit dealing with the factual issue. And as you are saying, the CMOH report was not there. These documents were there. But why didn't your person place these documents?
That's one aspect. But for that, one should not be held negligent, Malad, if it comes to your lawsuit.
If a person is left on the street, Mr.
Malad,
Sannal,
I tell you, lawsuit, he was not left on the street. I tell you, lawsuit.
what document you have to show it to us that it was not a
That's
case?
why, Malad, I have taken your lawsuits,
proceeded-
4 pages.
No. At what time was the patient brought to your nursing?
10 a.m. He was returned back 10:29 a.m. I have to assess, Malad. I searched my bed in 2 departments. First ICU and again, my lord, isolation. In the meantime, I carried out the test. But what negligence I committed?
All right. Yes.
Before taking to the learned commission says, I have not taken into emergency. Before doing that, I have to take it certain things because he was in the well-equipped ambulance. It's not that he doesn't have any oxygen support, all that. He was with full support by the SI.
He was not brought within the nursing home. He was in ambulance and keeping the patient there. You wanted to find out whether there is any vacancy.
COVID-19 period, your lawsuits, anybody before doing that, he has to be checked up at that time. It's not normal period, my lord. It's not a normal period. Before somebody holding responsible on the charge of negligence, one has to consider this. Report of the medical college, it's not a valid one, your lordships, accordingly.
Yes.
Doesn't give any credence because it doesn't have any sample collection date, time, nothing. After 6 days, they received it according to them.
Yes.
Therefore, now your lordships, one kindly come to page, the impugned order, the relevant portion.
Page 164.
164. This starts at page
164.
160. I have I have there are twice, I think, the order your losses will find. 130, I have read your losses. Kindly come to page 130.
So you made your petition stronger.
Now it's your lordships.
So if he was not COVID positive, you were then in a position to give him the treatment.
Malad, that's one point because we ASI with a specific direction, admit you the patient in ICU. I didn't have the bed. No, that's the specific. I can take your losses to the ASI.
It says ICU, and if you don't have a bed in ICU, there's a ITU, there's a ICCU. There are a whole lot of departments where you can give some treatment.
Midland nursing home.
No, do you get into these intricacies, or do you actually want to give treatment to the persons coming to you?
I want to give treatment.
You want to give treatment. So if he was not COVID positive, as you say, then you would have given him the treatment.
Good, but not in ICU. General bed, might be general bed, but that would be another act of offense. They said you have to I have a tie-up, and they have directed me to take ICU.
Where is that page?
ICU,
that reference of ESI?
I just. Your lordships will find only several pages they have said. I give you losses. That.
Exactly.
Well, kindly come to just এখানে আজকে যেটা ওনারা দিল ওটা বার করুন। Page 106. Very paragraph A, the very first two lines. How the patients are sent by ESI. The patient being referred by ESI hospital comes with referral quotations with an advice of ICU ventilation for each patient as usual.
106.
106.
106.
That is your letter to.
Yes, that we informed them that you asked us to give him admission in the ICU.
Where you are reading?
Page 106.
Oh, that clause A.
A and B, both your losses kindly consider. আরেকটা জায়গায় দেখো তুমি আইসিইউ তে ভর্তি নিতে বলেছিল আমাকে।
Yes.
So this was not a case, Malad, that this was not directed. Your losses called from the record of the ESI, the losses will find it. That because of this, they sent me. They sent to us. Now, I was referring to page. একটু ভালো করে দেখ যে কোথায় ইতে দিয়েছিল আরো ভালো করে দেখিয়ে দিতে যে আইসিইউ তে নিতে বলেছে। I was placing just now your losses. Page 133.
133.
133. The order, Malad, under of the single judge. It starts from page. That twice 130.
Hey, please come to 164 because we proceeded on that basis last time.
All right.
If you are having no problem.
It starts from 164.
Yes.
Just Malad, page 167. I will tally and I will make my submission.
No, if it is inconvenient.
No, you're not. Malad, paragraph 10, your losses first. The petitioner argued kept the patient waiting outside its precincts and never admitted the patient, which led to the harassment of the patient party. More importantly, it is strenuously argued that only due to faulty COVID report. Far from the gate, it Malad, faulty COVID report. Medical college report now. And this was not the case before the commission either. Because ultimately the order of the commission we are questioning. Without having actually tested the patient properly, several other hospitals refused to admit the patient.
That is their contention.
Their contention. Then you'll see paragraph 11. two reports filed by the government hospitals involved herein, namely Sagar Datta Hospital and Calcutta Medical College Hospital, are nothing but an exercise to pass the buck regarding the cause of death of the patient. Kindly see below paragraph 12. The Calcutta Medical College and Hospital, without referring to the reasons for keeping the patient waiting from around 1:30 p.m. to 4 p.m., straightway addressed the issue of the patient having been taken to the general emergency at 3:30 p.m. on the fateful day, that is July 10, 2020. It has been alleged that some medical procedure was undertaken by the Calcutta Medical College and Hospital to the best of their efforts. However, the patient could not be saved. Lord, I'm not taking anybody's case. My Lord, this had happened number of occasions at that material point of time when the COVID outbreak. Because there was no seat anywhere. So many patients from one hospital to other hospital. Kindly visualize what happened at that point of time. Nobody is not a case of blame game. Doctors did much. Their best the doctors give at that point of time. Insofar as the Sagar Datta Hospital is concerned, it has gone up one step further and has alleged in paragraph 5, as per the records of the patient available in the record section of the College of Sagar Datta Medical and Kamarati, no such patient found.
No, that is their infirmities. So that is why Sagar Datta liberty was granted, proceed against them.
Now the Calcutta Medical College and Hospital.
Yes.
But kindly see your losses, paragraph 14 then. This court not satisfied at all with the explanation given by the College of Medicine Sagar Datta as well as Calcutta Medical College Hospital with regard to the role played in the said demise of 18-year-old. Reverting back to the case of petitioner, the petitioner undertook a COVID test and found out the patient was COVID positive, which led to issuance of a COVID positive certificate by the petitioner number 1. The matter had gone up to the Chief Medical Officer of Health, and upon police complaint lodged by the parents of the patient against the hospitals, from a show-cause letter dated such as I placed before lawsuits, it is evident that one question posed in the show-cause letter against the petitioner was that the petitioner could not produce any evidence of medical intervention for stabilizing the patient before returning back to the Kamarati ESI hospital. If it is further alleged in the show-cause letter that the petitioner number 1 establishment had failed to produce any documents for approval of commencement of the said test and from the competent authority as well as the evidence of performing the said test. But rapid antigen test, no approval was required. No approval was required because it was certified by the All India Medical Association. But for immediate cause, you do it. They are subject to, I will show from my reply your lawsuits. Now this is the show cause. I gave reply, but the reply, after reply, there was no action. So therefore, reference to this, according to me, immaterial. This is a question posed to me by the show cause letter. I answered to this. Thereafter, the government has not proceeded against me. So it has to be presumed the government didn't have anything against me. Then your losses, by a written explanation thereto, the petitioner stated that the patient being referred by ESI hospitals comes with the referral quotation with an advice of ICU ventilation for each patient. This is, they sent only for this purpose to us. And there was no difference in the case of patient concerned. It was further stated, they have quoted the entire thing. The learned single judge have given to the entire reply, if I'm not wrong, and then your lawsuits. Then your losses, kindly see page 171.
Mr. Sharnal, kindly come to page 170.
170. Okay.
Now,
Malad,
fifth line from the top. On being informed by the
petitioners,
was back by ESI without
the said patient was allegedly summoned back by the ESI authority without delay.
Next, by way of further explanation, the petitioner state in the reply that this particular case as a special case. The COVID kit check was undertaken allegedly in discussion with ESI and visually.
Allegedly, Malad, using by the Malad, I do not know. We have not said allegedly, Malad. We have said that with their Malad discussion with them. So these are the steps, Malad, taken.
Case No, petitioner has also stated in the reply that it was not using COVID kit for a single case other than this and not and are doing RT-PCR only for detection in collaboration.
That's
a single case.
a single case I had done.
You have not, this is not a procedure adopted by you in general that whoever comes, I will do this.
Malad, I tell you, lawsuits, this has done why? If this test what is being done, that is not antigen test, I had to do it because I have a direction of the ESI to take it ICU. I do not have bed. But if I have to go into ICI or Malad, the isolation, so I have to be sure with that because other patient will be contaminated. So I have to do something. What the negligence part of it, my lord? Negligence part, I kept him pending, my lord, standard in the ambulance for 25 minutes. That's not the case of negligence, my lord, in the instant case. One has to, my lord, consider the entire background of it. The when this
totality has
totality of it. And I didn't say, my lord, anything. I checked up my bed position. I checked up twice in 2 departments. In the meantime, I carried out this. Malad, at that point of time, without checking antigen test, no one was taken into the even Malad staircase of the hospital. I was taken, my lord, but the food on the through the door, my lord. I was taken. I performed your lawsuit the duties regularly court. Then I was, my lord, ultimately suffered from this. So this was not a my lord, this is not a normal situation. And the admitted factor lawsuits cumulative effect, patients suffered malad high sugar, blood sugar, right from the malad ESI hospital with cough, fever, and malad breathlessness. These are all the prima facie symptoms of lawsuit. So they had to carry out.
Yes. Yes, anything else, Mr. Sharma?
Kindly, then, paragraph, then your lawsuits will find. Paragraph 22 and 23. From 20 year lawsuits. Just have a look at 20. I'm not placing it year lawsuits. '23. Insofar as the present petitioners are concerned, its liability is limited to 2 aspects. One, issuance of COVID positive certificate without having any proper infrastructure to do so. This is now the charges are changed. Commission held one thing, and kindly have a look at. Secondly, not examining the patient in its emergency or giving preliminary treatment. But I putting a question to myself so for the second aspect. Then I will go to the first. Malad, what could your lordship expect from the nursing home at that point of time in regard to giving preliminary treatment? Unless I admit him, I could have admitted him in ICU. I could have given any treatment, my lord. Kindly consider this. Unless referral was had come to me with the advice of admitting the patient in ICU. And for that purpose, I didn't have bed. What preliminary treatment I could have given to the patient without being taken him to the ICU? I tried my best to take him to the isolation. Isolation didn't have bed also. Isolation is not for him. Even then, your lawsuits.
Yes.
Then second, your lawsuit, issuance of COVID. I had carried out it for the benefit of all the patient and for him also. Kindly visualize. After that, Sagar Datto, Calcutta Medical College, both the government college, at that point of time, test certificate could have been obtained on urgent basis even within 12 hours. I didn't have that much of facility because I am not a COVID designated hospital. And I am being helped now, negligent.
Yes.
No. Consider such, then commission considered such issue and observe the could have been examining the patient in emergency. I am joining an issue. I am not repeating my submissions, your lordships. This is not the correct, my lord. Then your lordships can. Then paragraph 25. The question is not whether the patient was suffering from COVID or not. The issue is whether the patient was properly equipped to conclude patient was suffering from COVID, sufficient to deter the patient from being admitted to most hospitals. How could they say every hospital took him? Sagar Datto, they said that they are every affidavit is not clear. They firstly said no such patient came to us. So for medical college, their allegation, they kept him stranded for 3 hours. And this was not before the commission.
Yes.
So, my lord, according to me, my lord, this ultimate order of the commission, my lord, the commission should be directed to consider all these. I am not signing off, my lord, signing off to face the consequences. But without doing that, I should not be blamed.
Yes.
So, Lord, kindly, my lord, remand the matter to the commission and let them consider each and every evidence, examine it, and come to a finding.
Yes. Thank you.
My lord, this case has a short history. My lord, on the fateful date, ESI doctors advised us to take our son to Midland Nursing Home at Belghoria. ESI arranged for their own ambulance for our son, and we reached at Midland Nursing Home at 10 a.m. Everywhere we have stated this in the before the police complaint, before the police also, as well as before the West Bengal Health Regulatory Commission, same version we have stated. We sat there for at least 30 minutes inside the ambulance. We were not even allowed to even come out of the ambulance. Half an hour waited outside the hospital, even without any.
Where from you are reading this?
My lord, I am reading from my note, but my lord, it has been stated in my opposition also. I have made a short notes in my opposition. I have read. I have stated. Thereafter, my lord, father dialed 100. Father.
At what time?
My lord, at about 10:30. At about 10:30 or 11. 10:30 to 11. Lalbazar police, they said, they gave us the phone number of Belghoria police station and they said to contact Belghoria police station. My lord, Belghoria police station initially did not pick up our phone. Thereafter, after picking up our call, they did not do anything. Thereafter, I did one thing. In the meantime, my lord, several reporters were there. I said, I shall commit suicide if my son do not get any medical assistance. Thereafter, one of the staff, I do not know who was that staff, he came out. He just took a blood sample from my son's finger and went out. Within 2 minutes, my lord, he came back. And my lord came back with a sheet of paper. I am showing only stated COVID positive, no number, no assess. Page number 30 of their stay petition, page number 30. Page number 30 of their কি ওটাই তো দাঁড়াও পেজ নাম্বার 30 স্টে পিটিশন তো কোথায় আছে না এই দাঁড়াও এক মিনিট পেজ নাম্বার 30 তে দাও আগে পেজ নাম্বার 30 of their stay petition. Page number 30, my lord, kindly sees. Page number 30.
Yes, we are on.
Thereafter 31, next page. Page number 30, 31. Patient came to severe respiratory distress. My lord, there no number has been given, no assessment number, no number only. My lord, what they did subsequently, my learned senior friend, my lord, did not say this. If your lordship kindly comes to page 29, subsequently they made this page as a forged page. Page 29 kindly comes. This was not before the commission. They, my lord, only to save their own skin, they have prepared page 29 as they have given me initial medication, but that was not given. But only to save their skin, they have come. My lord, kindly see once, my lord, page 29. This is another offense. In page,
they could not place it before the commission because they did not file any affidavit before the commission.
No. My lord, kindly comes to page 81, 82. For my sake, my lord. My lord.
The final order was passed on
22nd May 2023.
22nd, 2023. This was without any records from the part of the nursing home.
Yes, we have filed
Now,
documents.
the nursing home, Mr. Sannal's argument was that in the first order, CMOH was asked to inquire and report. Thereafter, he was not given any copy of the report, and he had brought the other communications to the notice of the commission, but that was not taken into consideration. There was no affidavit. That is his contention.
There
The
was no
previous-
affidavit, but due to their fault, they did not appear even. My lord, it has been reflected in the order passed by the learned commission that they initially neglected to appear before the commission. They were neither their lawyer was coming.
It was COVID time, Mr. Chatterjee.
No, it was virtual mode, my lord. Hearing was taken in virtual mode.
You were present.
Yes.
You were virtually.
My lord, twice I went there. I can go, my lord, they cannot. But for them, my lord, there was virtual mode. They did not appear once, my lord.
No, at the time of passing the interim order, they did not appear. First order,
My lord,
87,
on first occasion they appeared. Thereafter they did not. So, my lord,
final order was passed on 10th September. Sorry,
22nd May. 22nd May 2023. Page number to bolo. Yes, 22nd May 72. Page number.
My lord, we appeared, my lord, before the commission on this. My lord,
on both the occasions you appeared.
my lord, yes, my lord, yes, my
For
lord.
the interim orders.
Before the interim order also, my lord, and my lord, may I point this out, my lord, the proper copy of the complaint was not even given to us at this time.
All right.
In front of. কি বলছে?
এও করতে গেল। হ্যাঁ, তারপর yes. You're appearing for whom? Autorup Banerjee is appearing for whom?
For commission.
For commission, I appear on behalf of the commission.
All right. Yes. Yes.
Thereafter, my lord, I was showing. My lord, kindly allow me to show first. Before the commission, my lord, this document was placed. Page 81, 82. Kindly comes. Their stay application. Page 81 of 82 of their stay application. Your lordship has seen. Now, my lord, kindly comes to page 29. Where from this document they are producing on one of the pages.
No, that page 82 is similar to page 30.
Yes, page 82 is similar to page 30.
Yes. What you
And
are
next
saying?
page is similar to 31.
Next page mane? Now, what you want to argue? You said page 29 was
Yes.
not placed before
Not
the commission.
placed. Subsequently,
but it was dated as 10 July at 10:20 a.m.
Yes. This was placed before this honorable court only, my lord, to save their own skin, and this is forged. And this is another offense which they have committed before this honorable court. On one hand, you were saying you were unable to provide any medical assistance, and thereafter you sent the boy to the ESI hospital once again. And on another hand, you were placing this emergency treatment sheet. This cannot be.
All right. Yes.
Thereafter, my lord,
Show us the police complaint. Police complaint.
Police complaint in our affidavit in opposition.
No, it was here also.
In our affidavit in opposition, page number 38. Page number 38, 39, 38 onwards in our stay application. 37 is the formal FIR. We have lodged complaint against all the 4 hospitals. It was never our contention only to catch this Midland nursing home. We have lodged complaint against all the 4 hospitals because we think they are responsible for the death of my
When
son.
did you ring the police? Is anything stated here?
Yes.
In your page 38 complaint?
Yes.
Page 39, এরপর 30 মিনিট
My lord,
রাস্তায়
shall I read the complaint, my lord? Shall I read?
না অনুরোধ করা সত্ত্বেও কোনো ব্যবস্থা এরপর আমরা
Page 39, 4th line. I'm reading, my lord, I'm reading. from page 38, fifth line I'm reading. আনুমানিক ভোর 5:30 নাগাদ আমরা ভিড় এড়াবার জন্য হাসপাতালে পৌঁছই।
No, we have read that. We have read that.
Thereafter page 39, এরপর আমার স্বামী 100 ডায়াল করার পর সেখান থেকে বেলঘরিয়া আইসির নম্বর দেন। ওনাকে ফোন করে উনি বলেন আপনি আপনার লোকাল থানায় জানান। আমার স্বামী বলেন এটা তো বেলঘরিয়া থানার অধীনে। তখন উনি দেখছি বলে ফোন কেটে দেন। এটা 10:07 সকাল 10:30 ঘটনা। এরপর নার্সিংহোম থেকে আমার ছেলে রক্তের নমুনা সংগ্রহ করে কিট টেস্ট করে। তাতে 3 মিনিট পর ওরা জানায় আমার ছেলের কোভিড পজিটিভ। আমার এবং ভর্তি না নিয়ে ফেরত পাঠিয়ে দেয়। COVID positive, they are saying what type of test they did? They did a COVID kit test. And thereafter, they are saying which has been admitted, which has been accepted by the Honorable Single Bench, that by visual interpretation, what does that mean? I am asking myself. Whether there was any scientific method, only visual interpretation.
Why your sample was taken?
My lord, sample was taken. There must be some records. Nowhere this record was placed.
No, that is page 38. Sorry, that is page 30. Page 30 of the petition. COVID KI positive.
That is only
referred to higher checkup.
My lord, for
No
COVID,
time was given.
no time was given, and my lord, for every COVID kit test, one identification number is required. There, that identification number was also not given. That's why they stated that by visual interpretation.
Where do you?
Yes, yes, I'm reading, my lord. ওই visual interpretation কথা হ্যাঁ হ্যাঁ বলেছে এই কমিশনের ইয়েগুলো বলো পেজ 105 my lord, I'm coming, my lord. পেজ 103 ওটা খুব আশ্চর্য
Visual interpretation.
107, my lord, kindly comes to 107. My lord, I shall read from page 104 because these 3-4 pages were not placed by my learned senior friend. Kindly comes to page 104. Before that, these were the queries. Page 103. Page 103. Kindly arrange to supply the below noted information for the purpose of investigation.
Yeah, just one minute.
Visual কি যেন কথাটা? Visual understanding.
You'll find that at page 170.
Yes, my lord. Page 107.
170 also
of the honorable single bench. Yes, honorable single. Yes, my lord.
I was telling my lord I saw it somewhere.
Yes. I'm grateful, my lord. I'm grateful. My lord,
visual understand.
My lord, they did not do anything. Only by seeing the outmare of the boy, they thought that he is suffering from
Now,
COVID.
this has been quoted, na? Visual understanding.
My lord, sorry, my lord. Sorry, my lord. Sorry.
তখনও তো টেস্ট রিপোর্টটা পাইনি stated that for this party as a special case checked a COVID kit in discussion with ESI and the visual understanding of COVID kit. So this was not a plasma test. This
No,
was
my lord, no. My lord, if we do that in our home, then also, my lord, there must be a report in the website. Online uploading. Online uploading. Here, there was no online uploading.
But what is page 29 then? Page 30 then what is that? Page
That was a simple white cheat paper wherein the staff of the nursing home wrote on pen that COVID positive.
But that was placed before the commission.
That was placed before the commission, and
Commission
commission did not
quoted that.
rely upon that. Commission did not rely upon that. Because, my lord, everyone knows wherever a COVID test will be done, that will be uploaded in the website. Here, there was no number. They admitted that by going through the visual interpretation, they thought that he was suffering from COVID. And from then, our ill luck started. No hospital was ready to admit my son. No hospital was ready.
And ultimately, it was found that I am not COVID positive.
Yes. My learned senior friend was saying that why the sample was taken on 16th, because post-mortem was done on 15th. Post-mortem was done on 15th and sample was taken, sample sent for FSL on 16th, and report came on 17th that he did not die due to COVID. On which date sample was collected, we did not know, but sample received on 16th.
What is the cause of death in the PM report?
My lord, he was suffering from breathlessness. His age was 17 years, few months. And my lord, he was suffering from high blood sugar, that is admitted. But for the entire day, my lord, he suffered from paucity of oxygen. Not a single amount of oxygen was supplied to him. And in the ambulance, he was saying that ambulance was well equipped. My lord, there was no oxygen cylinder. That's why, my lord, in our submission, each and every hospital is responsible.
Where have you said that there was no oxygen?
My lord, this was collected from this. I got the instruction, my lord, because the parents were sitting inside the
All right.
ambulance.
Yes. Anything else, Mr. Chatterjee?
My lord,
To sit down. She's losing her. Ask the lady to sit down.
okay.
Why did you tell her to come?
It must be a
My lord,
harrowing experience for her.
yes.
You
Yes.
shouldn't have asked her to come, Mr. Chatterjee.
My lord, I never ask, my lord. I never ask, my lord. They
This whole
come,
thing
my lord.
must be a very
Each and
painful-
every day, my lord, they come. I have never asked, my lord.
Yes.
My lord, where I was when I was submitting that COVID Midland stated at about 11 o'clock that my son is suffering from COVID positive. Again, I was taken to ESI hospital, but not on ambulance. This time I took my son on auto. Yes, on auto, because my lord, ambulance on in the,
No, for that the nursing home cannot be.
not that, my lord, but they are responsible, as they have said that my son is suffering from COVID. Finished. His life finished.
Yes. What do you have to say?
My lord, shall I submit?
No. Anything else you want to
My
say?
lord, yes, my lord, thereafter, my lord, the entire timeline is required, my lord. From ESI, my son was taken to Shagor Datto Hospital. From Shagor Datto, he waited there for some time. Again, my son was taken to Calcutta Medical. Oh, again to ESI, and thereafter to Calcutta Medical College at 1:30. And my lord, he was admitted at 3:39. My learned senior friend was showing a document that Calcutta Medical College also, they have seen that blood pressure is readily, that was falling down, because my lord, no amount of oxygen was provided to my son. That is the reason. Ultimately, he died. Not only that, my lord, he died at night. What time? At 9 p.m. I was informed on the next date.
At around 6 a.m.
At around 6 a.m. My lord, if your lordship sees the order passed by the learned single bench, honorable single bench, my lord kindly comes to the order passed by the honorable single bench. Paragraph পেজটা বলো তো, পেজটা আগে বলো। তুমি না ওনাদেরটাই বলো না। আচ্ছা আমাদেরটাই বলছি। My lord kindly comes to my opposition. Page number 54 onwards. Page number 54 onwards.
54
Para
is
number
the
16.
court order. Court order you are showing.
The order
54 is the court order.
Court order. My lord, some relevant paragraphs are there. All these parts were all these submissions were considered by the
Which
learned-
paragraph you are
My lord, paragraph 54, page 16 onwards. Oh, sorry, page 54, paragraph 16 onwards. From a show cause letter.
We have already been taken
Yes,
through
yes,
those
yes.
paragraphs.
And my lord,
The Shandal has taken us through.
my lord, this is required. My lord, kindly allow me to show few more lines, my lord. How they are, my lord, taking a subsequent plea before this honorable division bench. From a show cause letter dated July 24, 2020, annexed at page 63 of the writ petition, it is evident that one question posed in the show cause letter against the present petitioner establishment was that the petitioners could not produce any evidence of medical intervention for stabilizing the patient before returning back to Kamarhati ESI hospital. There, my lord, they were unable to show any document. Here they have attached another document that initially one medical assistance was given. It is further alleged in the show cause letter that the petitioner number 1 establishment had failed to produce any documents of approval for commencement of the said test from the competent authority, as well as the evidence of performing the said test. By way of a written explanation thereto, reply to the show cause, the petitioner stated that the patient being referred by ESI hospital comes with a referral quotation with an advice of ICU ventilation for each patient, and there was no difference. In the case of the patient concerned, that is Subhrojit Chattopadhyay, since deceased, it was further stated that the patient had already been stabilized in ESI hospital, wherefrom he is getting, I do not know, and had come in full support and guidance of ESI hospital Kamarhati. On being informed by the petitioners regarding non-availability of bed, the said patient was allegedly summoned back by the ESI authority without delay, for which reason the petitioners were not authorized to conduct any medical intervention, and so were not able to provide any evidence of the same to the investigating authority. By way of further explanation, the petitioners stated in the said reply that for this particular case as a special case, the COVID kit check was undertaken, allegedly in discussion with ESI hospital. No discussion was done. Kamarhati, and the visual understanding of COVID kit was only shared with ESI hospital Kamarhati for the benefit of patient. No such record is there. The petitioners also stated that said reply that it was not using COVID kit for a single case other than this, and are doing RT-PCR test only for detection of infection in collaboration with government approved center. Such explanation of the petitioners, however, regarding the COVID test is not sufficient, even expressly. If the petitioners do not use the COVID kit for a single case other than the present case, it defies logic as to what prompted the petitioners to undertake the said test in the present case. That apart, the allegation of visual understanding of COVID kit only being shared with the ESI hospital Kamarhati is extremely vague to suppress one offense, one after another there, my lord, committing offense. However, from a comprehensive perusal of the reply of the petitioners, it is seen, even apart from the COVID test, purportedly conducted by the petitioners, there was another ground for not admitting the patient, the same being that all the beds in the petitioner number 1 establishment was full. As annexure P16 page at page 82 of the writ petition, the petitioners have annexed a chart indicating the bed profile and the patient names of the fateful day.
Yes.
When the patient in question met with his demise, that is on July 10th, 2020, which indicates apparently that all the beds and CCU units were full, being occupied by patients on the said date. However, said list does not find any place in the discussion of the commission. Before the commission, you did not place this list. লাইসেন্সটা কোথায় একটু কথা বলি place those submissions before the commission. They are saying they are placing those submissions before the Honorable High Court. Last two lines, apparently was not produced by the petitioners before the commission. It is seen from the observations of the commission that the incriminating evidence against the petitioners, which was considered by the commission, was that when the patient reached the petitioner number 1 establishment, it was the bounden duty of the establishment to examine the patient in the emergency. ICU was full. What about emergency?
Emergency was also full.
Then, my lord, before inside the ambulance, at least the life of the boy was much more important, my lord. They did not do anything. They did not even, they tried to stabilize the patient. All right, my lord, admission is not required. To stabilize, at least to provide some oxygen, at least to stabilize them, that was also not done. This is offense, my lord. The fact that the patient was not allowed to go inside was not in dispute. It was observed the establishment could only dispute the COVID positive report. The commission held that even if full credence was given to the same, it would not find any plausible explanation why the said authority could refuse preliminary medical aid to a patient. The plea of the absence of vacancy was also considered by the commission, and it was observed that it was taken for the first time at the final hearing on March 15, 2021. The commission recorded that there was a specific assertion on the part of the complainant to that effect on affidavit, and the C was given opportunity to file counter, but they did not avail the same. Mere verbal submissions, that too on the final day of hearing.
We have gone through it. Any particular issue, anything else you want to point out? In reply to what Mr. Sannal has submitted,
Yes,
have you
my lord.
left out anything
Page
else?
98.
Show us that.
They do not have the license. The license was of prenatal diagnostic technique. They do not have the license of running a nursing home. Page 98 I have annexed.
Page 98 of your opposition. That was not the subject matter before the commission.
No, not subject matter.
We need
Not
not
subject
go.
matter, but my lord, they are committing offense one after another.
No, we are in judicial review of the order. Whatever is there.
My lord.
Yes, who is for the commission? Commission anybody?
My lord, we have lodged complaint before the Directorate of Health Services also against the government
liberty
hospitals.
was granted to you.
My lord, liberty was granted and we did that. We are not saying that they are only responsible. My lord, another thing, my lord. Commission, my lord, in my humble submission, shown mercy to them because up to 50 lakhs, my lord, could have been given as compensation as per law.
No, section 33 gives 10 lakhs only.
No, 38, my lord. 38, subsection 9.
Subsection 1
of the Act.
No. What
have the power to award such compensation as deemed appropriate, not exceeding 50 lakh rupees.
No, section 33.
33 is
10 lakhs in case of death. 10 lakhs in case of death.
Yes.
The commission has given you 5 lakhs.
5 lakhs. My lord, we are saying all the hospitals are responsible because no one tried to stabilize my son. No one. My lord, we are not running after 5 lakhs, my lord. One after another case they have filed. We did not file any petition anywhere apart from lodging complaint before police and, my lord, before the commission.
That is their constitutional right. What can whatever order we pass, either you can go up, they can also
yes,
go
my
up.
lord. Yes, that is true. But we have not come. We have not come before your lordships for the amount.
Mr. Sandal, any reply you want to give?
Would your lordships want anything further?
No further. We are not wanting any further response.
The answer as I want to give you is stabilize. My learned friend harping the word stabilize. He came up with a full support of ESI. What stabilization I will do? I'm harping on the repeatedly. Commission's finding is that preliminary medical treatment. Unless I could have taken him to the ICU, I could not have given anything. First, my lord, ICU taken first, referral will be given oxygen and the other machine support. That I have to give first. Now, before me, he was for 29 minutes. Everything had been done during this COVID period. My lord, your losses, kindly bear with me the situation over the entire country at that point of time. I think at least first, my lord, nobody has blamed the doctor community during the COVID period. Nobody has blamed. We might have been blamed, my lord, but now the doctors have never been blamed. They have got much credence from the society.
Only one line, my lord. We have not come against any doctor. We have come against the administration of the nursing home. You did nothing. Only you did a white paper wherein COVID positive was written falsely. That's all.
The present writ petition.
The damage was done by you.
My lord, what has been my lord's observation, my lord? My lord, may I ask what has been my lord's observation, my lord?
We have dismissed your petition. কি অরিজিনাল সাইড ডাকো কে আছে বল What is this, Mr. Dotto? It was mentioned before us.
Milord, this pertains to Milord subsidy scheme or incentive schemes, Milord, of the state government. Milord, Mr. Mozumdar's client had applied. Milord, we had released, or the state had released, Milord, a part of it, and thereafter it has been stopped. Milord, a writ petition has been filed, which has been allowed, directing the authorities to make payment. Now, with the urgency is, Milord, a contempt proceeding is pending, Milord. We have sought for time at least 10 times. So it's becoming very difficult to pray for time over there. So, Milord, we had mentioned so that at least your lordship, if the hearing starts, at least we can tell the honorable single judge that the matter is under consideration before the division bench. This is, in fact, Milord, the pressing need for mentioning the matter. Now, Milord,
WP? Yeah, When is the contempt, Mr. Mujum?
Well, the contempt has been posted on Friday.
Day after tomorrow.
Day after tomorrow.
What do you say?
Well, let the hearing commence. Well, we have been waiting for quite some time.
Yes, yes.
Repeated adjournments were taken. So, well, now the matter is coming up for hearing before the Honorable Division Bench. The Lordships may hear out the appeal. Because otherwise, my lord,
Writ petition was on affidavits.
well, a
Writ petition was on,
petition, no, a prayer for affidavit was made.
no prayer was made.
No.
That I cannot say,
But I was there. No prayer for affidavit was made. In fact, state did not appear. Repeated notices were sent to the state government council. Nobody appeared. WBIDC was represented. The matter was argued by WBIDC council for WBIDC, and thereafter this judgment was delivered. My lordship will find.
You are appearing for both the appellants.
Yes, yes.
And
I'll appear for
there
both
is
the
one
appellants.
order. If your lordship kindly takes one order, dated 13 November 2024.
So then, Mr. Mujumdar, they must have made some amendments in their stay application, maybe.
Yes.
Any factual issue is involved? Do you want any? Do you want to
Well,
put in a line to that, or?
But there is no requirement for evidence.
Milord, in fact, one of our submissions was
If
this
you
is
know
a question.
factual issue is involved, very well. Then you need not
There
file.
is a question of interpretation of the scheme. Because facts are not disputed.
But I agree with Mr. Mozumdar that this can be heard out, Milord, because there is no disputed questions.
How long will you take, Mr. Dotto?
But I'll take, Milord, some time.
No matter you take any lesser time, what is happening, Mr. Dotto? Now it should be lesser. This much time you missed.
Yes. Give me give me half an hour maximum. Because I'll tell you, Lordship, may I formulate the point? May I formulate the point for your Lordship's consideration? Where the scheme was framed, the scheme is that certain incentives would be given to the extent of fixed capital investment made by the establishments. Mr. Mozumdar's client is one of those establishments who have applied under the scheme. saying that they are going to go for an expansion program where they would set up 3 additional units, one at Khordha, one at Kashiang, the other is at Holdia. One of the units were not set up. Now, what is the incentive they'll get? The incentive that they will get is that they would get a refund of 75% of the sales tax paid in a particular year. This benefit will be given to them in the next year. Whatever is paid, 75% would be reimbursed in the next year. But that is the scheme. And the investment that they would make is around 400 crores. Now, our case is that number one of the units were not set up. Number two is the investment made was not to the tune of 400 crores, but to the extent of 144 crores. And what, Millard, we had released this or reimbursed them till a particular time, that is up to 2010, 2011, and thereafter we did not reimburse them. So therefore, Millard, they had come up, Millard, for enforcement of the benefits under the scheme. Now, Millard, this has been allowed, that this repetition has been allowed in favor of the...
Petition was of 24.
Yeah, this
So
was of
paid
20...
up to 24.
No, we have paid up to 2010, 2011 financial year.
But why such a belated application?
That is one of our points. That is one of our points. Limitation was also a point. Millard, I may not have to take the point of limitation if, Millard, I am right on the other issue.
So the entitlement for subsidy, this is the issue.
This is the issue. Now, Millard, one point, Millard, which I would be taking up as the first point is, Millard, this kind of a claim is not enforceable in court. Why it is not enforceable in court? Because, Millard, the benefit or the subsidy or the incentive, whatever is it called, Millard, is refund of a percentage of sales tax that is paid. But Supreme Court is categoric on this issue from 1992 onwards, that there can be no legislation also for refund of tax. There can be no agreement for refund of tax. And there is no promissory estoppel on refund of tax. And consequently, there cannot be any enforcement of a claim for refund of tax. Now, the mechanism may be different. One may call it an advance for the next year. One may call it an exemption. One may call it by some other name. Nomenclature may be whatever. But at the end of the day, I pay 100 rupees tax in, say, 2010, 2011. I get back 75 rupees of that in the next year, say, 2011, 2012. Now, this conceptually, constitutionally, is not permitted under our system of law. Because
but that is your scheme.
Yes. Their Supreme Court says that it cannot be enforced
even though there is a scheme.
Even though there is a scheme. And well, in 2022, the Supreme Court goes to the extent of even saying that was in a case of a BIR scheme, BIFR Sikh industry, certain exemption of sales tax were given, and the exemptions were granted till a particular time, like in our case. And thereafter it was stopped. When it went for enforcement, the High Courts allowed, the Supreme Court said that no, since it is not permissible in law, now allowing them to refund or directing them to refund after a certain period of time would be amounting to perpetrating a wrong which the court can.
Only one submission.
But it's not a refund, it's an incentive.
Yes.
Only one submission.
So the refund, that's what I say, that whatever is the nomenclature.
But refund can only be from the authority who's making the payment.
Right.
So incentive is not a refund.
Look, we call it an incentive. Now, incentive is the name given, but the benefit
correct me, Mr. Datto, incentive and refund, it's just not a change of nomenclature. They're completely separate things.
Yes. But here what is happening is, though it is called an incentive or a subsidy, whatever, but the benefit that they are getting is that they get refund of a portion of the tax that is paid.
Well, only one submission.
If take an example, they don't pay a tax for a particular year.
May I just indicate, this ground is not taken in the memorandum of appeal.
No. It's a point of law. I'll satisfy this. I'll satisfy your lordship. I can take it in a collateral proceeding also. A point of jurisdiction which has been held from by the Supreme Court from 1962 onwards. Shochindranath, I believe, Chatterjee, I believe that case is, where Milord Justice Ashutosh Mukherjee's judgment was quoted, where the Supreme Court said that we can do nothing but to quote the words of Sir Ashutosh Mukherjee, which says that what is the jurisdiction of a court? The jurisdiction of the court is to entertain, frame issues, decide, and carry it into execution. My basic case is that it cannot be enforced. So therefore, in a sense, I am also saying that the court, the writ court also does not have jurisdiction. But those points I'll take later on. These are finer aspects which I'll go on later on. But fundamentally, if the scheme is, fundamentally, if I may frame the question in this way for your Lordship's consideration, the question which requires to be addressed by your Lordship is that whether a claim for refund of tax can be enforced through the court of law.
অন্যদের জন্য কি করছে এই সাবসিডি স্কিমের the scheme is
Well, we
meant
have
for
stopped.
many entities.
Milord, we have stopped number one, and number two, Milord, there is a legislation which has been recently passed where we have scrapped all the schemes.
You have this
Scrapped
scheme
all
is
the
no longer there.
No, scheme is no longer there, but I may not require to trouble your Lordship with that in this matter. I may not require. These schemes, Milord, have all been scrapped from the inception of the scheme. But possibly that will not be required over here. Therefore, my Lord, subject to I'll be assisting your Lordships on this. Now, to answer this question, obviously, my Lord, the claim must arise from either some law or from some scheme or from some contract, etc. Now, whatever is the source of, my Lord, the right or creation of the right, my Lord, the question, my Lord, which needs an answer from the court is whether this right can be enforced in a court of law. Where the Supreme Court is very categoric, it is not enforceable. And my Lord, I cannot, I means the legislature of a state is also, my Lord, not empowered to legislate any law for refund of tax. Therefore, what your Lordships will find, but revenue is my learned friend subject, not mine. In income tax, where if I pay 100 rupees more in a particular year, where I get refund of that 100 rupees more. In sales tax, if somebody pays more than what is payable to the department, he gets back. Now, with interest or without interest is something different, depending upon the statute. But, my Lord, at the end of the day, going by the Constitution, my Lord, the legislature can only levy and collect tax through law or framing law. So the constitutional provision says collect and levy. There is no provision in the Constitution which permits framing of a law for refund of tax. But, my Lord, the refund of tax is only, my Lord, limited to the extent that whatever is paid in excess of what is payable is obviously refundable. Now, these are the schemes. Yes, my Lord, I accept, my Lord, these were meant to encourage entrepreneurs, to encourage, my Lord, setting up of industries. Well, I have got certain factual aspects to, my Lord, argue. I don't say these are disputed facts, but still, my Lord, there are certain facts to be argued. For example, number one. Number one is, if you have promised to invest 400 crores and have invested 144 crores, whether you stand in the same footing or not. But digressing from my main legal point for the time being. Number one, if you have promised to set up 3 industries and have set up at 3 places, and if you have not set up an industry at the most difficult place, that is Kashiang, we're encouraging industry at Kashiang for generating more employment over there. If you have not set up that, whether you can come and claim or not. Number 3, of course, is limitation. I don't know whether at the end of the day I'll take it or not. There is a point of limitation. And number 4 is interpretation of a clause of the offer letter, because the Honorable Single Judge has held that whether or not they have invested 400 crores is immaterial. Have they invested more than 25 crores? If they have invested more than 25 crores, therefore they are entitled to all the benefits.
Due to paucity of time, the learned advocates appearing for the respective parties, due to paucity of time,
for hearing.
But some observation, my lord,
Naturally, my lord, there no need for any observation, my lord. But naturally, my lord,
we
adjournment,
have said that due to paucity of time, we couldn't complete.
that is why, my lord, some early date. Only that is what I am seeking. Only that is what I am seeking, nothing more.
26 থেকে কিছু আছে হ্যাঁ on 26th at 2 p.m. But finish it off on that date,
Yes,
Mr. Dotto. Make
Sir,
it a bit,
give me half an hour, my lord. I formulated the point. Nothing much to say on facts, few judgments, and my lord,
if you can finish it off,
25th, my lord, 25th.
25th, yes.
25th, my lord.
25th.
That's the old difficulty. First half, my lord, there is no problem. First half is appellate side matters are taken up.
They will come on 3rd July.
3rd July, my lord,
The
it will
next
take us to
Thursday.
1 more month.
No,
But this
no,
is
they are-
continuing for last 7 or 8 months.
Which one?
This contempt and this appeal.
Then let Mr. Dotto finish it up on 26th.
On 26th.
On 26th, let it be there. If you are not being, Mr. Roy will be there. If if you cannot come, then we will consider keep it on another day, or we will finish it off. Please provide us a date when we can.
24th, my lord, 24th, 23rd, 24th,
23rd এ হবে না।
27th, yes. 27th, whichever day, my lord.
27th is Friday.
Well, we can try all like at 2 p.m. Well, everything happens after 3:30.
To 3:30, how long will take?
2 p.m. my lord, we can take that. 27, 20, 20, 20.
Mr. Mujumdar will come on 3rd.
Well, third, my lord, I am not here at all. I am not in Calcutta at all. Well, any day, my lord. This month, my lord. Kindly speak.
Then we have to
16th and week
26th কি রাজার সাথে? Then 26th 2 p.m. Mr. Dotto, 26th Friday.
27th, my lord, Friday.
Sorry, it is 27th.
Friday is
27th,
27th Friday.
26th.
Wait a minute. 7th বলছেন দর্শক।
ও বাবা, তাহলে কি করবো বলো, ডেট একটা দাও তাহলে। 27 তারিখ কি চ্যাটার্জি সাহেবের সাথে?
27th তারিখ is Friday.
ঠিক আছে, ওটা বলতে বলতে
30th my lord in the second half.
30th 2 p.m.
2 p.m. 100.
ঠিক আছে, আপনার কটা আরো ফিক্স আছে?
No,
আর ফিক্স করে দাও। 30th as fixed at 2 p.m. করে দেবেন। দুটোতে একসাথে
এই 7 নম্বর। এই না, ওটা করলো না 7 নম্বর। হ্যাঁ।
স্যার ওই 19-এর জন্য
কালকে পরশু কি অ্যাডজার্নমেন্ট?